Yes, all the list. Right,
Number one.
I am for the petition. Milot, after recovery of this girl, she has already submitted few letters to police station and district police superintendent. Her medical test has not been done yet, and her family is under major threat of the accused persons. And that day, police personnel told that there has been arrested one person, but unfortunately, this person is frequently threatening mother and father of this girl.
Now the girl has been recovered.
Recovered.
Now she is in a home, or
She's in a home.
she is in a home.
But regarding medical test, police personnel is completely ignoring, and after repeated application of this girl, medical test has not been done yet, and her family is quite major threat of this.
That is not within the purview of habeas corpus. Habeas corpus purpose has been served. Your girl has been recovered.
Primarily served.
Your girl has been recovered. What more do you want? Further, what more do you want? Now, if they are threatened, who is the state?
Proceeding under POSCO.
Who is the state?
State is not appear.
State last occasion appear.
Last
Subrata Chatterjee.
proceeding under POSCO, her family is one. Proceeding under POSCO.
Is there any case registered by police?
Police. In last occasion,
My lordship, I'm for the state, my lordship, the reports are right. May I submit?
Where is Pajamulli?
My lordship, she has not reached the court yet.
And where is Debabrata Chatterjee?
I know. Arekta report.
ask me. Lordship दिए थे.
It may be referred to surgeons as hospital for
the center. Hospital.
চাইছে প্রথম দিনই তাকে অ্যারেস্ট হয়েছিল জানো.
Now Horipada has been arrested.
Horipada has been arrested.
Her statement has been recorded, and the investigation is still proceeding. They have added 6 POXO. Everything has been done.
Lordship on first day, state informed that one person was arrested.
That Horipada is the person with
one co-accused is there, name is Rothin Mondal.
Where is Pajamulli?
My lordship, she has not yet come to the court. She is on her leave.
Ask him, we will take it up at 1 o'clock.
1 o'clock.
Oh, acha, acha. Come her to come. We are giving a short passover. You ask her to come. Please wait.
Come on.
The passover. Passover. The file টা দাও। কিন্তু ম্যাটারটা সেম আসার কথা ছিল।
আপনার ম্যাটারটাও মনে হচ্ছে না ঠিক আছে, এখানে তো দেখাচ্ছে সরস্বতী দেবী।
এটা লিস্ট থেকে বের করে দিই। আমরা তন্ময়ের সামনে এই ফাইলটা
of 2 years 7 days.
Lordship, I am for the petitioner. Lordship, this is an infractious matter.
wait, take care. তো ওটাকে there has been an error. Your matter has mistakenly appeared. Some other matter was mentioned here. Now, what has happened to your matter?
Lordship, in this matter has been filed for the habeas corpus matter. Husband couldn't find out the wife, but somehow.
Take your seat. Take your seat.
Lordship, this is an infractious matter because the husband
So this
has
has
found.
wrongly appeared. This has wrongly appeared. It will go out of the list.
Go out the list.
This has wrongly appeared. This matter was not mentioned by you. Your matter is Saraswati.
Lordship,
Some other matter was mentioned. এটাকে লিস্ট থেকে বের করে ওইটার অ্যাডিশন করো। করে করেছো।
Acquisition. Malad. It is that matter, Lordship, can you remember, Malad, where my appointment, Malad, was not considered in the post of substitute helper in the railway because of the fact, my lord, the headmaster, my lord, wrote to the authority that
Oh,
my
let
certificate.
it be after vacation. You heard it along with Justice Chatterjee
As your lordship.
after vacation.
Pursuant to your lordship direction, my lord, I served a copy of the original application to my learned senior.
You have availed information, availed instruction.
Yes, my lord.
We take it up after vacation when the because it was heard by my brother along with me. Take it up after vacation.
As your lordship. Great.
Yes, next.
Item number 5, I am for the appellate. My lord, I am for the respondent,
Oh.
my lord.
Last
I am
occasion,
praying,
Lordship.
my lord, I am praying, not this week, my lord. I am not keeping well, my lord. I am suffering from fever. My lord, I have to leave the court.
Come after vacation, Mr. Vishnu.
Yes, my lord.
My Lordship, this
Moreover, we heard it extensively with my brother was there. It will appear after vacation.
Yes.
It will-
Lordship, let
My-
it be fixed any date, Lordship. My lady,
It will appear in the list on the reopening date.
the same heading, the fixed matter. Lordship.
So many things we cannot predict. It will appear this much we can say.
Much.
If you or you agree to a date, we will keep it on that date.
No, Lordship, if Lordship not fix this matter, it is too much difficult to enlist this matter. Lordship knows very well.
Who told you that it will not be enlisted? It will be there on the reopening.
But with the both side, Lordship, kindly pass any order, Lordship.
What order is to pass?
Let it be after vacation, let it be fixed as a fixed
It
matter.
will appear on the reopening date. No necessity of fixing. Yes, next.
Much.
But I am for the petition of this matter. My client is out of salary, my lord, for more than 1 year, my lord. Last
Who's your
occasion,
other side, Mr. Das?
Mr. Chatterjee. Mr. Nandi, last occasion, my lord has only directed whether any vacancies are there or not. I have downloaded from the official server 151 vacancies are there in the Director of Ordnance, my lord. Despite the order passed by this court, they are not allowed me to resume duty, my lord. And my family is starving, my lord. More than 1 year I am without salary, my lord. And last occasion, my lord, Harrowed at length and
This bench did not hear.
my lord and Honorable Justice Rai Chakraborty.
We keep it on the reopening date, Mr. Das. We will hear on that.
And I am without salary.
It will appear in the list on the reopening.
Same heading, my lord.
Same heading এই রেখে দিও।
Yes, my lord.
Yes, that habeas corpus matters, other side has come. Yes, call the
Lordship, mother of this victim girl has come to this court, and family is very much obliged to this court within 24 hours of this order.
matter the list.
Her daughter has been recovered.
Where is your other side? We will dispose of the matter. We will, other side is
Item number 1 and 2.
One.
Six is showing. Or item 6 to the dark দেখাচ্ছে বটে বোর্ডে শো করছে item
what
6.
happened? What happened?
In item 6, I am for the respondent. The board is showing or displaying the item 6.
Item 6 was just now called on. Mr. Das was there. We have kept it on the reopening date.
Very well, my lord. But may I submit my hand over my sleeve? Very well.
It will appear on
On
the
6 on the opening. Good.
Seven.
দেখো তাহলে এবার একটাতে 7 নম্বরটাতে 11টার সময় নাকি 7 নম্বরটা ডাকো Where is the petitioner? You wait, Mr. Chakraborty.
Your Lordship, I am appearing for the petitioner on behalf of my learned senior. I am praying for a short passover. He is engaged in another courtroom. He is just coming, Your Lordship. Short passover. I am appearing for the petitioner. Item number 7.
Yes, you have availed instruction.
Yes, my lord, I have got instruction. My lord, in this matter, I am being led by Mr. Vasco Prasad Banerjee. He is also on his legs.
Short passover, Your Lordship. Very short passover.
Passover.
Grateful, my lord.
Much obliged.
My pleasure, Your Lordship. My lord, but this matter, my lord, pertains to, my lord, my recovery from the salary. And I was praying for the interim order in this matter. My lord, my learned friend, my lord, was appearing on the other side, whom, my lord, I have served, my lord, in October 4 by hand. The affidavit of service is also read. Lordship, on the earlier occasion in this matter was taken up, my lord was pleased to direct me, my lord, to peruse the judgment of the Honorable Supreme Court in state of Punjab's, High Court of Punjab's case.
Have you ascertained that any further amount they are recovered?
That was also my lord's query, my lord, I ascertained from January onwards, my lord,
You have
each
stopped here. You have
each
been-
and every month it is being deducted to the tune of 59,000 per month till today. Now, my lord, what happens?
That
the-
is not your case in the.
My lord, that I tell your lordship that there was no order passed that this much amount will be deducted from your salary. No order passed. That is my specific case before your lordship. And it is being deducted each month. Now, my lord, my daughter suffers from cancer, for whom, my lord, right now I'm in Karnataka, my lord, for her treatment.
Where have you stated all these things?
My lord, it is a subsequent fact. My daughter's, my lord, tumor has been found to be a cancerous, and now I am there in Karnataka.
Who is your other side?
My lord, earlier occasion, my lord, appeared.
Senior advocate is in fever, unable to come today.
Okay. Who? Take your breath. Take your breath. Take your breath. Take your breath. Sit down and take your. Oh,
ASG. Planet ASG, Your Honor.
who is your age?
I don't know. I'm
I don't know, my lord. Ashok Chakraborty, sir.
Mr. Ashok Chakraborty, sir.
Ashok Chakraborty.
Yes, Your Honor.
The additional Solicitor General.
Additional solicitor.
There must be some junior.
None available, Your Honor. My lord, just give me instruction on my phone.
He's praying for an interim order. We have to decide that.
None available, my
To
lord.
send information, ask him to appear on that 2 p.m. We will ascertain.
My lord. My lord.
My lord, subject to my lord's lordship convenience, can it be at 1 or 2:30? My lord, I'm a matter fixed at code number 8 at 2.
Mr. Chakraborty has come or not?
No, we are unable to.
Then who is his junior in the matter?
Mary Datta.
Huh?
Mary Datta. Mary Datta.
Learned advocate,
Learned
Miss Mary Dutt.
Miss Mary Datta.
Where is she?
She's unable to come today due to her personal problem. I think.
কি বলবে বলতে তো সব।
My lord,
My lord, may kindly be fixed.
We are keeping it at 2:30. All right.
My lord.
Ask somebody to appear because we have to consider the interim order. If nobody appears, we will be constrained to hear him and pass necessary order.
My lord.
Yes. All right.
grateful.
Matter, my lord, I am appearing for the appellate petition.
এই ফাইলটা দাও।
This is a case, my lord, for appointment to the post of Constable GD in the Central Armed Police Force. An advertisement was made for appointment to the post of Constable, my lord, in the first week of November 2022. Then petitioner Millot applied for the same. Then written test was held.
Hmm.
Then written test was held. Petitioner appeared for written test.
This is appearing for the first time.
Yes, Millot. First time, Millot. Only, Millot, I am praying your Lordship, Millot, to direct the respondents, Millot, to submit a report in terms of annexure P6, Millot, subsequent medical report, Millot. Page 33 onwards, Millot.
Who is your other side?
I have given notice, Millot.
What given notice?
I have given notice, Millot. Also, Millot, before mentioning, Millot, I have also given notice, Millot.
You gave the notice?
Yes, Millot. Before mentioning, Millot, I have given the notice, Millot. Also before that, Millot, I have served of all respondents, Millot.
So what interim order you are praying?
I am praying your Lordship, Millot, to direct the respondent to submit a report, Millot, in terms of subsequent medical report, Millot, page 33 onwards, Millot, annexure P6. And all only report is necessary, Millot. And also I am praying your Lordship, Millot, দিয়ে দিন এটা দেন, দিয়ে দিন, আমি সার্ভিস করেছি সবাইকে। রেজাল্ট
Selection is over.
Yes, Millot, panel has been published, Millot, in the first week of August, Millot. Appointments are going on, Millot. Vacancy will be filled up today at any time or tomorrow, Millot. Then I have mentioned this matter before your Lordship, Millot. Now I am praying your Lordship, Millot, to submit a report, and also I am praying your.
What
keep-
purpose will be served for that? Panel has been prepared.
Yes, Millot, published, Millot.
Where have you stated?
I have stated, Millot. I have stated, Millot. Panel has been prepared, Millot. Appointment are also going on, Millot.
What interim order you are praying? Tell us.
I am praying your Lordship, Millot. Since, Millot, appointments are going on, Millot. And now, Millot, I am praying your Lordship, Millot, to keep the one post, Millot, for the
Where
petitioner,
have you
Millot.
prayed for that? Where
That-
is your prayer?
That, Millot, I am sorry, Millot.
Then
Other prayer, Millot. And to pass such further order,
the first prayer which you are required to make, you have not made that prayer. How can we help you?
prayer B, Millot, may consider
Prayer
here
B is for what? Prayer B is
to
for
pass such further order,
No,
other
further
order or
orders.
others, Millot. To keep, Millot, on, I'm sorry, Millot. It may be excused, Millot. In other matter, Millot, one,
who are the respondents? CRPF.
yes, Millot. 2 and 4, Millot.
Who appears for CRPF? You have given notice to the central government advocate, that is Union of India.
I-
They are not concerned with this.
I have served of all respondents, Millot. I have served, Millot. Of all respondents, I have served, Millot. I have served, Millot, of all respondents, Millot.
Unless you make out a case that panel has been published, appointment going on, nothing you
Yeah.
have stated.
Panel has been published, Millot,
So
in
So
the
we
month
will
of
call
August.
for a
Millot.
report that will serve your purpose.
Yes, Millot. Only report, Millot, in the
So you are not praying for any interim order.
interim order, I pray for one post be kept, Millot. Because, Millot,
Where have you stated that panel has been prepared, everything has been done, appointment is going to be given? Unless you make that averment, how can we help you? Who appears?
Then, my lord, it may be disposed of, my lord, in terms of Annexure P6, my lord. It may be disposed of, my lord. Subsequent medical report. Respondent 2 and 4, my lord.
Who appeared for CRPF in the writ petition? Who appeared?
Earlier occasion, my lord, Mr. Kumare Dalal was there, my lord, for the respondents.
You survey notice upon Mr. Dalal who appeared for the respondents. Survey notice, ask him to come at 2 p.m.
Yes, my lord. I shall come. I'm grateful, my lord.
ওটা এসছে সবাই। ডাকো এবার।
Your Lordship, I'm praying for a very short passover. Mr. Mazumdar is just on his way, just 5 minutes passover.
How
Well,
many matters?
I'll take some time, my lord. Mr. Muzumdar is coming, my lord. Yes.
Your Lordship.
Yes. দাও ফাইলটা দাও।
There are two appeals. My lord, one was, my lord, an interim order granted for a limited period, against which, my lord, is the first appeal. And the other one is, my lord, extending the same interim order, for which, my lord, there is a second appeal. There are two appeals, mandamus appeals. Number, this pertains to, my lord, an order of transfer.
Which appeal you are pressing?
But I have to praise the parent one,
Parent.
yes, which is if MAT.
Said that the point, Mr. Mojumdar said that whether there will be 2 appeals or 1 appeal, there was a
No,
previous-
Mr. Muzumdar had raised this point when the first appeal was being moved. That
against the extension order.
no, it was against the parent order, but by that time the extension was granted. Therefore, my lord, according to Mr. Muzumdar, there should have been a second appeal
I see.
challenging the extension also. For which maybe we have preferred the appeal. Maybe I have not gone into.
What is that appeal number?
The first one is.
First one is on the basis of the first interim order which was passed.
Yes.
That is 1204.
Yes, first one is 1204, second one is 1910.
Yes.
Second one?
1204 is the first one, second is 1910.
So you are placing 1204.
Yes. Because the reasons of the honorable single judgment is there in 1204. Now, this is a case of transfer. My lord, the writ petitioner, my lord, is the employee of, my lord, the West Bengal Zoo Authority. Now, my lord, in the Alipur, the writ petitioner has been transferred from Alipur Zoo to, my lord, Rajarhat Zoo.
Now that, sorry to interrupt, that interim order was, first order was.
But the first order was dated
May 19th. May 19th.
yes, 19th of May 2023.
Now their interim order, now it was extended by a further order.
Right.
Now that interim order is subsisting till which
Because
period?
the extended interim order is till
November and 30th November.
till 30th November.
আচ্ছা। So till 30th November. ওই অন্য
30th
ফাইলটা
November.
কোথায়? আরেকটা যে ফাইল Yes, Mr.
Look, may I please the my lord order under appeal? 19th of May, Mr. Mozumdar, learned senior counsel appearing on behalf of the petitioner, prays for stay of transfer order by the order dated so and so, the member secretary of the West Bengal Zoo Authority. The petitioner has been transferred to Horinaloy Mini Zoo, Newtown, from Zoological Garden, Alipur. The petitioner has been working as a head clerk at the Zoological Garden, Alipur. It is the petitioner's case that under the regulations of West Bengal Zoo Authority, particularly Regulation 9(2)(b), the governing body had the power to conduct the overall administration functions, including sanction of post and appointment of employees of the authority. The governing body had the power to regulate the terms and conditions of service, that the terms and conditions of service of the employees already in service on the day coming into existence of the authority shall not be altered or varied to their disadvantage except by their consent was also stipulated in the regulation. The Alipur Zoological Garden Management Rules came into effect on November 6, 1957. The petitioner was appointed as a lower division clerk at the Zoological Garden on March 3, 1996. On March 1, 1998, the petitioner's service was confirmed. On or about September 14, 2010, the Joint Secretary of the Government of West Bengal issued a letter whereby the West Bengal Zoo Authority would take over the management of the government-controlled zoology parks, gardens, etc. By an order of September 14, 2010, the management of Zoological Garden Alipur was handed over to West Bengal Zoo authorities. Therefore, it is the contention of the petitioner that his condition of service as on the date of coming into existence of the authority, WBZA, could not be altered or varied to their disadvantage without his consent. Mr. Mozumdar also refers to the minutes of the 9th meeting of the governing body of the West Bengal Zoo Authority held on July 11, 2014. Agenda 710 relates to transfer and posting. Under 710B of the officers and staff who were above the rank of zookeepers shall be treated as WBZA cadre and would be posted anywhere within the state of West Bengal. Officers and staff who joined the zoos prior to the establishment of WBZA shall only be transferred on request, complaint, and punishment. He submits that in violation of 710B, the transfer order was issued. Mr. Dotto, Senior Counsel, appearing on behalf of the respondent number 9, submits that only the member secretary to the WBZA who issued the transfer order has been made a party. The employer has not been made a party. The writ petition is not maintainable since the employer has not been made a party. Furthermore, the issues raised in the writ petition are covered by Industrial Disputes Act. Since the petitioner is a workman within the definition of the Industrial Disputes Act, he also submitted that an employee workman does not have any right to effect, stall a transfer, and as such, any policy or guideline governing the issue of transfer is not an enforceable right. Mr. Dotto further submits that the minutes of the meeting are not rules which govern WBZA. He also submits that zoo is an industry held by several judgments of the Honorable Apex Court. Mr. Shah, learned counsel, appearing on behalf of the respondents 1, 2, and 5, submits that the writ petition is not maintainable since WBZA is an authority under the Societies Registration Act and not a state within the meaning of Article 12. Therefore, the writ petitioner has an alternative remedy and should not have agitated the grievances by way of filing a writ petition. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that the petitioner was in employment at the time of formation of WBZA authority. Therefore, he was an employee who was absorbed by WBZA and has joined the service prior to establishment of WBZA. Therefore, on a conjoint reading of the regulation 9(2)(b) of the regulations and the minutes of the meeting of July 11, 2014, agenda 710B, it should be B. This court is of the view that the writ petitioner has been able to make out a prima facie case for staying the order of transfer, as he was not transferred, deployed on the basis of a request, complaint, or punishment. In such view of the matter, so and so is kept in abeyance. Now, my lord, so far as, my lord, these two provisions, one is a provision, the other is, my lord, minutes of the meeting. But first, kindly, my lord, have a look to, my lord.
No, in the regulation of 9(2)(b) of
Yes.
WPZA,
Yes,
there the condition was that it cannot be varied or altered, 7 except for.
yes,
And what is this agenda 710B?
yes. 710D is, my lord, without consent, according to them, my lord, there cannot be a transfer.
But
First-
that refers to 710B in the
Yes,
preceding page you have read.
Yes, it should,
Preceding page you are reading 710.
it should be B for Bombay.
Oh, I see. So the learned judge was of the opinion that you were appointed prior to WPZA, and prior thereto there was a condition that what was the condition
Yes.
prior to? All right, you please.
My lord, please have a look to, my lord. Appointed previously under the government.
You are appointed. We have challenged the person.
My lord, this appeal is at the instance of the zoo authority.
Yes.
Now, my lord, the regulation starts at page 97. My lord, the relevant portion, my lords will find, my lord, at page 102. So these are the two provisions, my lord, which have been applied for staying the transfer order.
This is the regulation. Regulation.
Powers of the governing body, my lord, at page 102. The overall administration of the authority shall vest in the governing body and the governing board, and the governing board shall have the necessary powers for that purpose, including the powers necessary for or proper for the achievement and the furtherance of the objectives specified in the memorandum. Without prejudice to anything contained in sub-regulation 1, the governing body shall have the power, kindly take B, to sanction posts and appoint employees of the authority and regulate the terms and conditions of their services, subject to the condition that the terms and conditions of the conditions of service of the employees already in service on the day of coming into existence of the authority shall not be altered or varied to their disadvantage except with their consent. This is one of the provisions, which has been resorted to, by the writ petitioner.
But this is 9(2)(b).
Yes. And the other is 710B.
But 9(2)(b) is not there in the order.
Yes, yes.
The order 9(2)(b) was there.
Yes, yes. Please come back, to the order. Fourth page of the order. Fourth page of the order, second paragraph, seventh line.
Conjoint reading
Yes.
of 9(2)(b) and the other is
710B.
That is at which page?
That, my lord, will find at page 124.
Of the same regulations.
No, this is a minutes of a meeting dated. I'll give you a lot of. It starts at page 117. Which is the governing board's 9th meeting minutes.
Yes, page 124.
Yes. Now please take me to page 124. This is part of, agenda 7 or the resolution, under agenda 7. Please take serial number 10 at page 124. Well, we are not concerned about A, so I skip over A. Now please take B. All the officers and staff above A shall be treated as WBZA cadre and can be transferred, posted anywhere within the state of West Bengal. Officers and staffs join the zoos prior to the establishment of WBZA shall only be transferred on request, complaint, and punishment. So, my lord, here, my lord, this was a.
Is above zoo
Yes.
cadre, then he will.
Then he can be transferred on request, complaint, and punishment. Above zookeeper, yes.
No, up to the zoo cadre shall not be transferred. That is A,
Yes,
except on complaint, punishment and representation. And officers above A shall be treated as zoo cadre and can be transferred.
yes. So he falls under B. Zookeeper এর উপরে তো।
So according, what is his designation? Present.
I think he's a clerk, na? Head clerk. Head clerk.
Your case is that he is above the. zoo.
Yes, yes. Well, there is no dispute between the parties made on that. That he is above zookeeper and say B would apply. There is no dispute on that.
Then let us, please show us the transfer order now.
Yes.
Page 103. এই মনে হয় transfer.
No, no, 102 টা।
134 and 135.
Yes.
134 release order, 135 transfer order.
হ্যাঁ,
134 and 35. Please have a look to 135 plus first
yes.
and then 134. 135 is for the management, for the better management of the so-and-so, the services of so-and-so as placed under the disposal of Horinaloy for deployment at Horinaloy Zoo until further orders. The order will have effect from 3rd May, that is on the same day. Then where the release order is the preceding page, 134.
No, Mr. Dotto, why is it being said that there is being an alteration of service condition?
Certainly not. This is my case.
Because earlier regulation said that you cannot alter what was existing prior to taking over charge.
Yes,
But
to
transfer
the
is an
disadvantage.
incident of service.
Right. But I've got twofold submission, primary. Number one is, transfer is an incidence of service. Therefore, there is no alteration of service. There can be no alteration of service. Number one. And number two is, assuming that agenda 710B at page 124, confers any right, assuming for argument's sake that confers any right on the employees concerned, that is transfer is to be made on complaint, punishment or on
No,
request.
that is not applicable because he is above zoo cadre.
No, but B applies to him. B would apply to him.
He will apply.
Yes, B would
So
apply.
in B shall,
B, as per B, a person above zookeeper can be transferred on request, complaint and punishment.
right, now in B, all officers and staff above A
Yes.
shall be treated cadre and can be transferred anywhere in the state. Oh, join the, oh, so in this case also the rider was added.
Yes.
So their argument must have been that as there was no complaint against him, you couldn't have transferred. That might be. Yes.
Now, this is their case. So, my first contention is, a transfer order, does not vary or alter, any service condition.
Yes.
And second is, keeping 710B as it is, without adding or taking away a word from it, whether it confers any right on an employee to resist an order of transfer. Or, in other words, whether it confers, 710B confers, a legally enforceable right or not. But these are, my twofold submissions before my lord.
But Mr. Dotto, if we read 710B once more,
Yes,
within the brackets, officers joined prior to a shall only be transferred. There is no other option on which you can transfer. When there is a request, when there is a complaint, and when there is a punishment.
Right.
These three riders prima facie is not fulfilling.
right. Therefore, my lord, if
And also he doesn't have a right to challenge the transfer.
In my very humble submission, my lord, these have all been, my lord, settled by your lordships, my lord. I'll just cite one or two decisions, my lord, to my lord.
Just your contention is that even if it is the 7B stands, and though there is a rider that he can only be transferred in case of request, complaint and punishment, then also if he is transferred, no legal right is infringed.
Yes.
So you are supporting that contention on what basis?
But first is, my lord, transferred orders, my lord, are, as your lordships have held, my lord, do not infringe any legal right. This your lordships have held. Now the fundamental is there has to be a subsisting legal right to enforce by a petitioner to approach the court under Article 226. Now, if transfer orders, my lord, does not infringe any legal right, my lord, in my very respectful submission, there is no question or scope of, my lord, enforcing a legal right before a writ court. Number one. And number two is, my lord, your lordships have also held that there are only two exceptions under which a transfer order can be interfered with. The two exceptions are, one is malafide, the other is a statutory rule or a mandatory statutory provisions of statute. Now, these are the two exceptions. Therefore, my lord, the writ petitioner, my lord, has an obligation to demonstrate before this court either one, that it is malafide, but that is not the case made out, at least not urged before the learned single judge. And number two, that this 710B is a mandatory statutory provision.
Your contention is it is just a
Just a meeting, just a meeting. Yes. Now, but my lord, I, for administrative purpose, my lord, I have started a new zoo over there.
It appears from the order of the single judge.
Yes.
She has observed that you have not filed any affidavit. I was intending to hear out the writ petition. Ground taken was appeal preferred, so we will not file. That is not. That is Mr. Dotto.
But by this time, my lord, we have
Interim order is we have filed.
Yes, yes.
So interim order still 30th. We will request the single judge to hear out the matter.
Look, please consider this legal aspect. If they do not have a right,
Mr. Dotto, what you are asking us to answer has to be answered on the basis of evidence. We cannot debar you from putting on records to substantiate your contention.
But I have, for the time being, Lord, we are, Lord, not dilating on facts. Lord, yes, you know. Bench, the division bench headed by Justice Standen, their lordships, when this matter was taken up, when my lord Justice Chakraborty was in the circuit bench, my lord, the earlier division bench was pleased to observe that we should file an affidavit before the appeal court stating that through his transfer there would be no cut in pay or in status or lowering down of status, but that we have said. But Millard, fundamentally, Millard, please consider these 2 points. But these are all legal points, Millard. Now, this transfer, this stay, Millard, have the trappings of finality. I don't think, Millard, my learned friend will dispute, that appeal is maintainable. So, my lord, without addressing, my lord, on the maintainability of the appeal, my lord, I will address your lordship, my lord, as to the scope of, my lord, challenging an order of transfer. Because no facts are involved over here. Now, my lord, please take me one of, my lord, those old, often cited decision of, my lord, of S.L. Abbas. Please have a look to, my lord, S.L. Abbas. Two judgments, my lord. I'll not burden the court with multiple judgments.
Mr. Doctor,
Yes, ma'am.
tell me one thing, what's the rationale behind taking such a minute agenda and taking such a decision in course of a meeting touching the administration of the zoo authority?
Yes, because my lord, there is a, as your lordships have found, my lord, from page 102, that my lord, the governing board has the authority to look into the management as well as, my lord, as well as, my lord, the service and the other administrative affairs. Please come back to, my lord, page 102 once more. Please take 191. 10291. Overall administration so and so shall vest, and the governing board shall have all the necessary powers for that purpose, including the power necessary or proper for the achievement and furtherance of the objectives. So, my lord, under this power, my lord, under sub regulation 2, this is provided.
Regulation 2. Oh, that 2.
9(2).
9(2).
Yes. And this power is a wholesome power. 9(2).
Now this page 124, that minutes which you are saying.
Yes.
That is of the governing body minutes.
Yes.
Minutes of.
It starts at page 118. Please have a look to the top. But the first judgment is only 2 judgments, but I'll not multiply judgments. First one is 1993, volume 4, Supreme Court cases. 93. 1993, volume 4, Supreme Court cases 357. But this is a case of, my lord, executive instruction. Ours is a case of mere, my lord, minutes of a meeting. Now, please have a look, my lord, what the Honorable.
Just one query, Mr. Dutta.
Yes,
Do
ma'am.
you have any other minutes or regulation pertaining to transfer? No, save and except this.
No, not to my knowledge, but to whoever general.
Yes. Yes, which paragraph, Mr.?
Please take, my lord, para 6 first. An order of transfer is an incident of government service. Fundamental Rule 11 says that the whole time of a government servant is at the disposal of the government, which pays him, and he may be employed in any manner required by the proper authority. Fundamental Rule 15 says that the President may transfer a government servant from one post to another. That the respondent is liable to transfer anywhere in India is not in dispute. It is not the case of the respondent that the order of his transfer is vitiated by malafides on the part of the authority making the order, though the tribunal does say so merely because certain guidelines issued by the central government are not followed, with which finding we shall deal later. The respondent attributed mischief to his immediate superior, who had nothing to do with the transfer. All he says is that he should not be transferred because his wife is working at Shillong. His children are studying there, and also because his health had suffered a setback some time ago. He relies upon certain executive instructions issued by the government in that behalf. Those instructions are in the nature of guidelines. They do not have any statutory force. Pausing here for a moment, my lord. In this case, my lord, executive instructions, my lord, were applied to resist an order of transfer, which is of higher pedestal, my lord, than, my lord, an ordinary meeting or minutes of a meeting, my lord, of a governing body. Now please take the next paragraph. Who should be transferred where is a matter for the appropriate authority to decide, unless the order of transfer is vitiated by malafidez or is in violation of any statutory provision. The court cannot interfere with it. Well, these are, my lord, the two exceptions, my lord, which the Supreme Court has laid down. While ordering transfer, there is no doubt the authority must keep in mind the guidelines issued by the government on the subject. Similarly, if a person makes any representation with respect to his transfer, the appropriate authority must consider the same having regard to the exigencies of administration. The guidelines say that as far as practicable, husband and wife must be posted at the same place. The said guideline, however, does not confer upon the government employee a legally enforceable right. Then the rest, my lord, I don't trouble your lordship.
Yes.
Instructions where the lordships have held that it is the residuary or residue of legislative power.
But Mr. Dotto, suppose regulation is of yours.
Yes.
You are saying my regulation has no statutory force.
Yes.
But still, I will follow the regulation for administration. Doesn't it seem to be incompatible?
Yeah, please consider this from a different angle. For running the administration, I may have to, at times, digress from the minutes of a meeting. Therefore, my lord, what is required to be considered by my lords is that does this have the character of a statute, or is it enforceable as a statute or a statutory right?
Yes.
Like, my lord, your lordships have on very many occasions have held departmental circulars, manuals,
Have no statutory,
they have no statutory force.
which is the other judgment, Mr.
Yes.
Dotto?
I mean, the other judgment is Shilpi Bose.
Yes, yes.
এত কথা বললে হবে না, মামলাটা পড়তে দিন। 91 supplementary to SCC 659.
91
Supplementary to SCC 659. আচ্ছা, আচ্ছা। 659, para 4. But these are all well settlement only to just, for the sake of citing, my lord, I am citing. Para 4. In our opinion, the courts should not interfere with a transfer order which is made in public interest and for administrative reasons unless the transfer orders are made in violation of any mandatory statutory rule or on the ground of malafide. A government servant holding a transferable post has no vested right to remain posted at one place or the other. He is liable to be transferred from one place to another. Transfer orders issued by the competent authority do not violate any of his legal rights. Even if transfer is passed in violation of executive instructions or orders, the courts ordinarily should not interfere with the order. Instead, affected party should approach the higher authorities in the department. If courts continue to interfere with day-to-day transfer orders issued by the government and its subordinate authorities, there will be a complete chaos, etc. Therefore, my lord, please take, my lord, placitum C. This sentence is very important, my lord, apropos my lord's observation. Even if the transfer order is passed in violation of executive instructions or orders.
How the service of this cadre is regulated by WBSR or any other regulation?
No, there is no service regulation as yet framed, I am told. ওটা কি স্টেজে আছে?
স্বামী স্ত্রী এক জায়গায় নেই বলে মনে হয় সেখানে স্টেশনের গেটটাকে
শুরু করতে বল।
situation তো other than this.
He's my enemy, you know that? He's not on my side. Which one is going on? 20 order থেকে যখন বের শুরু করছে
পুরো সেখানে ফোন করছে
ছয়টাও ডাকছে। ছয় কি আছে দেখো পেশেন্ট আছে, এইটা অনেকদিন ধরে আটকে আছে এটা। Yes. Well, these are my twofold submission that especially CP Bose, it says that even if it is in or contrary to executive orders and instructions, they do not violate any legal rights. Therefore, we go back to the fundamentals. No legal right, so nothing to enforce before a writ court.
Thank you, Mr. Yes, Mr. Mujumdar.
But may I take your leave?
Whether it has been disposed of or not.
Which one?
Run.
Lordship, first kindly take Lordship's kind consideration. The Memorandum of Association of the Zoo Authority, which starts at page 90, my lord. This is very important. How the Zoo Authority was constituted.
Page 90.
90, my lord, of the stay application.
There are two numbers, Mr.
My
Mujumdar.
lord,
Top one or
I think, my lord, the top one at the right hand top, because I think 58 is the
58. West Bengal Zoo Authority.
yes, my lord. 58 is
Memorandum of Association.
yes, my lord. My lord, it is 90, my lord. Actually, 58 is the running page of the writ petition, I believe, subject to correction. Now, my lord, kindly, my lord, this is how the Zoo Authority was constituted. It is a society registered under the Societies Registration Act. Now, my lord, kindly come to the members at page 94. Who are the members of this society? This is extremely important. But the first member is the Chief Secretary to the Government of West Bengal. The second member is again, my lord, the Secretary or the Additional Chief Secretary to the Government of West Bengal, Department of Forest. The third member is the Principal Secretary to the Government of West Bengal, Department of Finance. The fourth member is the Principal Chief Conservator of Forest. The fifth member is, my lord, the Principal Chief Conservator of Forest, Wildlife and Chief Wildlife Warden. And the last two members are the Director ARDD, my lord, this is Animal Resources Development Department, West Bengal, and the Director Zoological Garden, Alipur, Kolkata. Well, your lordship has been apprised that this writ petition of your lordship was employed prior to the constitution of this committee or establishment of this authority. Now, my lord, now kindly turn over and take, my lord, the regulations for once. Because I will also rely on these two judgments which have been cited by Mr. Dotto. My lord, kindly take page 97. The regulations start at page 97.
yes,
Your lordship will kindly take page regulation number 8, which is at page 99 of the stay application. Membership. So, my lord, all the echelons of the state government are the members of the Zoo Authority. Now, my lord, now kindly take, my lord. Sorry, this is 8. That was 3, I believe. That was regulation 3. My lord, I'm so sorry, my lord. Kindly take now 8. I have shown your lordship the members. Now the composition of the governing board. The governing board who decided, who took that decision in the 9th meeting. That is relevant. Who is the first member who will hold the post of chairman is the CS, Chief Secretary.
Where you are reading?
I am reading it. Paragraph 5. Regulation
Composition.
5 at page 101. Actually, the numbers are a little bit fudged in the printout, I believe. There shall be a governing body. My lord has got that, my lords. There shall be a governing body comprising, subject to the provisions contained in sub-regulation 3, all the members. 2A, the member mentioned in clause A of sub-regulation 1 of regulation 3 shall hold the office of chairman. But turning back to regulation 3, 3131A is the chief secretary. So it is the chief secretary who is the chairman of the governing board. B, the member mentioned in clause B of sub-regulation 1 of regulation 3 shall hold the office of vice chairman. The secretary department of forest is the, my lord, the vice chairman of this board. The officer nominated as a member under clause K of sub-regulation 1 of regulation 3 shall hold the office of secretary. Now, my lord, turning back to regulation 3, it is, my lord,
What is your argument?
my argument is that
All are state government.
not only that, my lord, I'm not on that. These are all high officials. These are the members of the governing body. There is a regulation in place, namely regulation 92B, which prohibits the authority from altering the service conditions of the existing employees. Your lordship has seen that.
That is we are wanting.
Now, my lord, if we take regulation 92B, my lord, in furtherance, my lord, what I should say, the spirit and letter of 92B is carried in the minutes of the meeting held on in 2014. It is 92B, which in its letter and spirit appears in, my lord, regulation in the 7th clause 7 or the agenda number 7 of the 9th meeting of the board. Now, my lord, now I take your lordship to 92B. So, my lord, 92B has to be read in conjunction with this agenda number 7 of the meeting.
So we have a query, Mr. Mohan.
Certainly, my lord, I will answer to that.
Effect that 92B says that there will be no alteration or variation to the disadvantage of the person,
Right.
except with their consent.
Yes.
Now, if a transfer is in question,
Yes.
how does it lead to
My
alteration?
lord, I tell your lordship how the disadvantage has to be. My lord, what is troubling your lordship? That if that transfer is not at all disadvantageous to an employee,
Yes.
how is he affected? But this disadvantage which is specified, the expression disadvantage, has to be read in the light of agenda number clause 710. It is how it has to be, my lord, read. Subject to your lordship's kind consideration, obviously. My lord, may I just read 92B first? My lord, subject to your lordship's kind consideration. Kindly take page 102. My lord, this is powers of governing board. The overall administration of the authority shall vest in the governing board, and the governing board shall have all the necessary powers for that purpose, including the powers necessary for the achievement and furtherance of the objectives specified in the memorandum, without prejudice to anything contained in sub-regulation 1. The governing board shall have the power, my lord, I am skipping A, I am coming directly to B, to sanction posts and appoint employees of the authority and regulate the terms and conditions of their services. Well, this is for the fresh employees. Subject to the condition that the terms and conditions of service of employees already in service on the day of coming into existence of the authority shall not be altered or varied to their disadvantage except with their consent. Now, my lord, 9.1 has to be first read with 9.2. So, my lord, any decision taken by the board would be in furtherance of the objectives specified in the memorandum. 9.2b says that service conditions cannot be altered to the disadvantage of the existing employees. Now, on a conjoint reading, if we take 9.1 and 9.2 together, 9.2b together, now, my lord, we have to read, subject to lordship's kind consideration. Kindly take, my lord, the resolution, which your lordship will find at page 118. It starts at page 118. Kindly take, my lord, the first paragraph at page 118. My lord has got that? My lords, my lords.
Yes.
9th meeting of the governing body of the West Bengal Zoo Authority was held on July 11, 2014 in the conference room of so-and-so. The meeting was chaired by Chief Secretary. My lord, the chairman and chairman of Zoo Authority. And the meeting was attended by Secretary, Department of Forest, Principal Chief Conservator of Forest, again Principal Chief Conservator of Forest, then my lord, Director Animal Husbandry, then my lord, Chairman of so-and-so, because my lord, some other zoos were also being set up. Then my lord, the all backward classes, etc. Then Director Zoological Garden Alipur, where I'm working right now. Then my lord, the PNH's part and etc. etc. Now my lord, kindly come to clause 10, clause 7, agenda 7. I'm sorry. But I have to read the. Kindly take agenda 7, which starts at page 123. My lord, I'm sorry, my lord, page
123.
My lord, it is, my lord, again the pagination, my lord, 123 is on the right hand top. The pagination is at the right hand top. My lord?
Yes, now that is page 109th meeting.
Starts at page 118.
Uh.
And my lord, I'm taking a lordship directly to 123, the relevant agenda.
Oh, irrelevant. Yes, that A and B.
My lord, kindly take, my lord, before I take your lordship to that portion, kindly take, my lord, what was the agenda about? Approval of the different issues of service and allowances to officers, staff of WBZA and different zoos under its control. The proposal as submitted, recommended by Technical Committee of WBZA, 10th meeting held on April 23, 2014, agenda 2 was discussed in detail. So, my lord, this resolution was taken pursuant to a decision or the recommendations made by a high-powered committee, so constituted by the Zoo Authority. The following decisions as recorded against each item in the table below were taken on the same. Now, my lord, kindly come to 10. My lord, clause A, 10A is not applicable. Clause 10A is not applicable. 10B, the exception clause carved out in 10B is applicable in my case. Now, my lord, again, kindly take, my lord. So, my lord, these were the service conditions which were approved by the governing board of the Zoo Authority. My lord, these decisions were taken to further the objective of the memorandum. These decisions were taken in line with regulation 92B. So, my lord, the expression disadvantage has to be read in the context of the decision taken in the 9th meeting of the governing body. My lord, an authority cannot say that I am not bound by my own decision. It can never say so.
What you are hinting is that then nobody can be touched.
No, only the existing employees cannot be touched. Only the existing employees cannot be touched. The existing employees of the Malad today, they are up against against an interim order before your lordship. Malad, what if your lordship allows the appeal, just for the sake of argument? What will be the consequence? My repetition will be infructuous from this day onwards. So, Malad, today they are seeking a dismissal of the repetition at this stage, at an interlocutory stage. Is it permissible? Malad, I put the question to myself with all humility. I think it is not permissible. Now, Malad, kindly take, Malad, now, who took the decision? Now, Malad, kindly come to page 127.
We have put that question to Mr. Dotto.
Yes, my lord.
That repetition is pending.
My lord, I tell your lordship, this is a case where, my lord, interlocutory order has to be in the nature of status quo, has to be preserved, that he is already in service, that he is already posted there. But I tell your lordship one thing, kindly take, my lord, the first judgment cited, this last judgment cited by Mr. Dotto.
Yes.
It will help my case. Kindly take for once. And then I will come to SL Abbas, which will again help my case. My lord, kindly come to first. Yes.
So Mr. Dotto is giving judgments which are helping you?
Yes, my lord. We have worked together for so long.
So that objective is continuing.
That objective is continuing. Very high respect, my lord, very high respect. My lord, kindly take, my lord, this 1991 supplementary to SCC 659. My lord, kindly take, my lord, Mr. Datta has read paragraph 4. Kindly take paragraph 2. What was the case about? The appellants are lady teachers in primary schools in state of Bihar. On their request, they were transferred to places where their husbands were posted by District Education Establishment Committee. Respondent number 4 to 8, who were displaced by the appellants, challenged the validity of the transfer orders before the High Court by means of a writ petition under Article 226. The High Court, by its judgment and order dated February 8, 1989, set aside the transfer orders and directed reposting of the respondents to the places from when they had been transferred. Now kindly come to, this is a case where transfers were made on the basis of requests made by the employees. Not at all applicable to the facts of my case. And my lord, kindly take for once, kindly take placitum H of paragraph 3. I will not read the entire paragraph 3. Placitum H. My lords have got placitum H. But the placitum H starts with, we fail to appreciate reasoning recorded by the High Court. My lord has got that. If the competent authority issued transfer orders with a view to accommodate a public servant to avoid hardship, the same cannot and should not be interfered by the court merely because the transfer orders were passed on the request of the employees concerned. The respondents have continued to be posted at the respective places for last several years. They have no vested right to remain posted at one place. The next sentence is very critical. Since they hold transferable post, they are liable to be transferred from one place to another. Well, I am not holding a transferable post at all. It is nobody's case that when I was inducted as an employee, the appointment letter said that I would be holding a transferable post. It could not be, because we had West Bengal, the Alipur Zoo. He was an employee of the Alipur Zoo. Now, my lord, the general observations made by the Honorable Supreme Court at paragraph 4. In our opinion, the court should not interfere with a transfer order which is made in public interest and for administrative reasons, unless the transfer orders are made in violation of a mandatory statutory rule or on the ground of malafide. Well, pausing here for a moment. No, I'm sorry, I must continue. A government servant holding a transferable post has no vested right to remain posted at one place or the other. He is liable to be transferred from one place to other. Transfer orders issued by the competent authority do not violate any of his legal rights. Well, in this case, the services were transferable and the transfers were made on the request of the employees, and those transfer orders were challenged. Completely different set of circumstances. Now the other judgment, the SL Abbas judgment. Kindly come to SL Abbas judgment. Then I will cite one or two judgments in support of my case.
No, you mean to say transferred on administrative ground?
Yes.
Transferred on the basis of a request.
Yes.
Is contrary to the nomenclature of the post, that whether it is transferable or not.
Well, it's a very, very important question put by your lordship.
You cannot use that nomenclature because your contention was it is not a transferable post.
It is not a transferable.
At the same time, you are saying that yes, you can follow the governing body minutes, which provides for an option for transfer at least.
Well, at my instance.
Yes.
At my instance.
But can you say, Mr. Mojumdar, that the court has to
so, my lord,
on the basis
but I tell you, lordship, I will cite a direct decision where, my lord, the transfers could only be made on the basis of option. Transfers were made without following that course in violation of office memoranda, and the transfer orders were quashed and liberty was given to the authority that if you take options, you transfer them. But coming back to SL Abbas.
No, but that does not affect the nomenclature of the.
I tell you, lordship, kindly take, my lord, kindly take. If your lordship kindly takes the, my lord, if I conclude with SL Abbas, then if I subject to lordship's kind consideration, my lord, my lord, pardon me, my lord. Kindly take paragraph 6, my lord.
Of
SL Abbas.
Yes.
An order of transfer is an incident of government service. Then my lord, fundamental rule is quoted. Fundamental Rule 11 says that whole time of a government servant is at the disposal of the government which is him, and he may be employed in any manner required by the proper authority. Fundamental Rule 15 says that president may transfer a government servant from one post to another. But there is no such provision here. An administrative instruction can never override fundamental rules. Your Lordship are dealing with these matters day in and day out.
Yes.
So in this context, my lord, SL Appa's judgment was rendered. Now, my lord, coming back, now a second, my lord, kindly take, my lord, I have in my writ petition pleaded malice. And the malice is apparent on the face of record now because of the supplementary affidavit used by the authority. My lord, kindly take, my lord, page 135 of the.
Did not go into that.
My lord, the wording of the order was not transferred. It was deployment. When they use the supplementary affidavit, they said, no, he has been transferred.
Yes. Mr. Bose, anything else in reply?
Lord, firstly, my lord, may I take from the last? It is also their case that they have been transferred.
Yes,
That is their
certainly,
petition.
certainly.
And in the affidavit, we have also stated that, however, it is
My lord, one or two authorities, may I cite, my lord? One or two authorities, subject to lordship's kind consideration.
my lord.
My lord, two authorities I will cite, nothing more. My lord, your lordship has dealt
No, we needed to go into the fact that the earlier coordinate bench gave you a leave to file a supplementary to establish
Yes.
that there has been no
Because-
change.
Because that was the apprehension, and we had, yes, my lord.
that was
Record, that is
Yes,
Mr.
yes.
Dotto's submission that there has been no reduction in the.
There has been no reduction. My lord, after the judgment.
My lord, only with regard to two judgments. My lord, first is 2004 4 SCC down. 2004 4 SCC. My lord, this is regarding the interim order.
2004.
4 SCC. 697. And one judgment on BS Minas I will cite.
আর তাহলে রিট পিটিশনে কি শুনানি হবে?
Then my lord, we go back to the writ court. My lord, my affidavit in reply is ready. It is to be affirmed today. I will serve a copy on Mr. Bose today and let the writ petition be decided at an early date. My lord, your lordship will kindly take, my lord, paragraph
697. Where is it?
yes, my lord, kindly take paragraph 12. Well, I got the interim relief that the transfer order may be stayed in the meantime. Right, my lord? That is the subject matter of challenge. This is one such case where this kind of relief has to be granted at an interlocutory stage. And I heavily rely on this judgment, paragraph 12. Your lordship have dealt with this judgment so many times, but still for the sake of, my lord, my satisfaction. Paragraph 12, situations emerge where granting of an interim relief would tantamount to granting the final relief itself. And there may be converse where the withholding of an interim relief would tantamount to the dismissal of the main writ petition itself. This is one such case. And my lord, now kindly take Minas. My lord, mass submission has been made regarding the 83, 83 na 84. দুটো দিলেই তো হবে, আর কি দরকার আছে? Kindly take Minas. This is 83 4 SCC 582.
That's, guidelines have statutory.
No, yes, guidelines are statutory force. And when an administrative authority sets certain standards, the administrative authority has to adhere to those standards while dealing with any kind of issue governing those standards. Kindly take paragraph 23. May I just read? The next question that arises for consideration is whether the appointment of the respondent number 4 as director of so and so is illegal because of non-compliance with bylaw 2. Bylaw 2 does require that before appointment, the vacancy in the post of director should be suitably publicized. In the instant case, it is admitted on both sides, no publicity whatsoever was given. The contention of Sri Garg, however, was that bylaw having no force of statute, non-compliance with its requirement cannot in any way affect the appointment of the respondent number so and so. Sri Tarkunde, however, argued that contended that assuming that bylaw is not statutory, even so, the respondent was bound to comply with it. In support of his contention, he strongly relied upon Ramanna Shetty. Well, this is very important. It is well settled, quoting from Ramanna, it is well settled rule of administrative law that an administrative authority must rigorously be held to the standards by which it professes. Well, I say the decision taken in the 9th meeting is the standard set by the authority themselves. They cannot take a stand which is contrary to those standards. Now, professes to be judged, and it must scrupulously observe those standards on pain of invalidation of an act in violation of them. Admittedly, my lord, these standards have been violated. Now, quoting from Justice Frankfurter, Vitarelli versus Seaton, where the learned judge said an executive agency must be rigorously held by the standards by which it professes its action to be judged. Accordingly, if dismissal from employment is based on a defined procedure, even though generous beyond the requirements that bind such agency, that procedure must scrupulously be observed. My respectful submissions before your lordship is that the authorities are bound by regulation 9(2)(b), rather regulation 9(1) and 9(2)(b), read with, my lord, agenda 7, clause 10 of the 9th meeting of the governing body. My lord, there is no other discernible principle for regulating the transfer of service conditions. So, my lord, they cannot take a stand which could be contrary to the regulations and the guidelines. But these are my most respectful submissions before your lordship. My lord, can I take your lordship?
Yes. Now you have when
Well, I will file the affidavit in reply today.
interim order is till 30th November.
Yes, my lord. Yes, grateful, man.
But even if we hold in your favor, you
Yes.
have to go back to the single judge for extension. We
Right, we
cannot extend the purview of.
No. We will go back to the one judge for this extension.
As you are leaving, we
No, I understand, man. Mala, may I take your lordship's kindly? Deeply grateful, man.
Lord, only points, my lord. One has, of course, my lord, almost followed from your lordship when it was said that it is not a transferable post, and my lord, reliance was placed in the 710B. 710B is, my lord, in fact, a provision which authorizes transfer and then puts a kind of an embargo. So it is not a fact that it is a non-transfer. Yes. Number one, my lord. Number two is, it was said that, my lord, yes, my lord, bylaws, my lord, if
Mr. Bose, suppose today you say, though there is a minute, though there is a regulation, I do not have any obligation to comply with this. Doesn't it become a bit
contradictory. Yes.
How you will run your administration?
So, my lord,
Today, if you seek a declaration from court that so far as transfer issue is concerned,
yes,
we will not follow that because it has no statutory.
my lord,
Then it will becomes more difficult for you to run the administration.
my lord, probably, my lord, relying on BSP NAS, probably this
If you say that in absence of rules it should to be proceeded, then everyone will start whimsically acting. I do not like Mr. Bose, I will send him away.
truly,
For prevention of such issue, regulations are there.
yes,
And there are executive instructions. What Mr. Dotto has submitted, Mr. Dotto submits that when there is a general execution instruction, as in central government and state government,
yes,
you find
yes,
husband and wife has to be
Yes,
placed in the
yes.
same place.
Mm.
Like whether any legal right originates on the basis of that.
yes,
These issues,
o-
Mr. Anyway,
on-
what is your next point?
yes, my lord. Two things, my lord. One is, my lord,
Transferable.
transferable. My lord, then, my lord, I say, my lord, before, my lord, the petitioners were even my lord, claim entitlement to an interim order, my lord, they must show or at least plead before the honorable court how, my lord, their terms and conditions of service have been changed. My lord, I stand to say, subject to, of course, correction, my lord.
To their disadvantage.
Yes,
That
to
is
their
what-
disadvantage. My lord, not a single sentence in the whole writ petition was there. Not a single pleading in the whole writ petition saying how it has been, my lord, changed for the, my lord, wards for them. Number two is, my lord, not even one single unequivocal positive assertion in the writ petition that, my lord, that it has been changed. Not how it has been changed, not it that it actually has been changed. Unequivocal positive assertion is absent in the writ petition. In that, even, my lord, probably, my lord, my lord, submit before your lordships that unless that case of change in terms and conditions of service is actually pleaded, or how it has been changed is pleaded, they are not probably entitled to an interim order. That is another point. And further, relying on BS Minas, probably, if I have understood correctly, they have tried to contend that even if something is not at the parlance of law, but if it is followed by the authority, then it must be followed, though it is not on the parlance of law. Probably, this whole thing can be boiled down to a assertion of kind of an estoppel on the state from its own decisions. Once the state decides, or once the respondents decide, it is a stop from moving away from that decision.
Yes.
On that accord, I say,
Yes.
on that aspect, I say that a government authority, while performing a function which is a welfare function, and this zoo authority's function is also a welfare function, it cannot be said that it is stopped by its own decisions. It has been very recently laid down in a Honorable Supreme Court judgment, 2023, Volume 1 Supreme Court cases. I will not cite, but that will be my respectful submission, that the government is not stopped from moving away from its own decision.
Yes, Mr. Sure. The appeal being MAT 1204 of 2023 has been preferred.
My lord, just one last thing, I forgot, that is why. One last thing. My lord, the question of interim order, the balance of inconvenience or convenience is seen before interim order is passed. There is no hardship on his part. There is no prejudice or hardship which cannot be cured. The decision which has been cited by Mr. Mojumdar, I also rely on the same, saying that when he says that irretrievable damage needs to be seen, even if he was allowed to continue in the Hodinalai Minizu during pendency of the writ petition, no irretrievable damage would be caused to him. However, I will suffer a very big trouble in running the administration, because of the Hodinalai Minizu, and October to February is the peak time, including the time of puja when the zoo is open. That is all,
The appeal being MAT such and such has been preferred, challenging an interim order dated 19th of May 2023, passed by the learned single judge in a writ petition being WPA 11723 of 2023. Stop. The other appeal being MAT 1910 of 2023 has been preferred, challenging an order dated 26 July 2023, passed by the learned single judge in the same writ petition, extending the interim order passed on 19th of May 2023. By which the interim order was extended till November 30th November 2023. By the order dated 19th of May 2023, the learned single judge exercised discretion in favor of the writ petitioner on a conjoint reading of Regulation 9 (2) B of the regulations relating to West Bengal Zoo Authority (bracket A in short WBZA) and the minutes of the meeting of the governing body dated 11th of July 2014. Mr. Dotto Learned Senior Advocate appearing for the appellants submits submits that transfer is an incident of service. Hearing, the writ petitioner has been transferred by the order impugned dated 3rd May 2023 for better management of Horinaloya Mini Zoo, New Town from Zoological Garden, Alipur. Stop. The said order does not in any manner put the writ petitioner in a disadvantageous position. Stop. In the interest of the administration, the order of transfer has been passed. And in the absence of any pleading towards malafide or violation of any statutory rule, the learned single judge ought not to have exercised discretion in favor of the writ petitioner. In support of such contention, reliance has been placed upon a judgment delivered in the case of Union of India versus S.L. Abbas. শিল্পী বসতে কোথায় দিল? S.L. Abbas, Union of India versus S.L. Abbas, reported in 1993, Volume 4, SCC 357. Mr. Dotto further submits that even assuming the regulation 7(2)B even if the decision of the governing body of WBJA pertaining to agenda 7(2)7 bracket 10 bracket B stands, the writ petitioner does not acquire any indivisible right to be continued in a post. Writ petitioner does not acquire any enforceable legal right. Does not enforceable legal right. No, to be gone, enforceable legal right. Stop. In the said conspectus and in the admitted absence of infringement of any legal right, the learned single judge ought not to have entered the writ petition. Stop. In support of such contention, reliance has been placed upon the judgment delivered in the case of Shilpi Bose, bracketed Mrs. and others versus State of Bihar and others, reported in 1991 supplement bracketed 2 SCC 659. Per contra, Mr. Mojumdar, learned senior advocate appearing for the writ petitioner stroke respondent number 1 hearing. Submits that there is no infirmity in the interim order passed and no interference is called for. Stop. Initially, the interim order was passed. Initially, the interim order was passed on প্রথম ডেটটা দিয়ে দেবে 19/5/2023, and subsequently the same was extended on by an order dated 26th July 2023. আচ্ছা ওই ফার্স্ট প্যারাগ্রাফে বলেছো না, as একটা লাইন as both the appeals arise out of orders passed in the same writ petition, the same are taken up for hearing together. ঠিক আছে, ওইটা দিয়ে দিও মিস্টার, ওই যে কিশোর দত্তর নাম দিয়েছো না, অ্যাসিস্টেড বাই মিস্টার বোস লার্নেড অ্যাডভোকেট করে দিও। এখানে হলো মিস্টার মজুমদার লার্নেড অ্যাডভোকেট। আচ্ছা কি ভুলে গেলাম, কি বললে? Per contra, Mr. Mojumdar, learned senior advocate appearing for the writ petitioner stroke respondent number 1. Hearing টা বলতে হবে, respondent number 1 submits that the interim order was passed on such and such 19 May and extended till the end of November by the subsequent order dated 26 July. Stop. The affidavits have been called for by the learned single judge, and initially the matter was also made returnable in the combined monthly list of September. Drawing our attention, next para. All points urged by Mr. Dotto. The order has passed. The main writ petition. The main writ petition is still pending. Drawing our attention to the provisions of regulation two, regulation 3, regulation 5. Drawing our attention to the provisions of regulations 4 and 5 of the said regulations. Mr. Mojumdar argues that all the top government officials are the members of the governing body. Convening a meeting on 9th, convening a meeting on 11 July 2014, the said governing body took a conscious decision under agenda 4, under agenda 7, that all officers and staffs এটা কি বললো? Above it, please look at it. Here, a conscious decision that the officers and staffs who joined the zoos prior to the establishment of the WBZA shall only be transferred on request, complaint, and punishment. By issuing the impugned order, they themselves have acted contrary to their own decision. Stop. He further argues that to decide the issue as to whether the said regulations and the minutes are applicable upon final hearing, comma, the learned single judge rightly granted the interim protection. Stop. In support of such contention, reliance has been placed upon the judgments delivered in the case of Devraj versus State of Maharashtra and others, reported in 2004, Volume 4, SCC 697, and E.S. Minhas and Indian Statistical Institute and others, reported in 1983, 4 SCC 580. Heard the learned advocates appearing for the respective parties and considered the materials on record. It is well settled that the regulations and the minutes and the decisions taken by the governing body needs to be read as a whole. A particular clause cannot be isolated and highlighted. Stop. Prima facie, there is a specific bar under regulation, under clause 7 to clause 7 bracketed 10 bracketed B, that officers and staffs who had joined the zoo prior to the establishment of WBJ shall only be transferred on request, complaint, and punishment. Stop. The issues as to the issues as to whether the said decision has any statutory force, or as to whether even if the said clause exists, the petitioner does not acquire any legal right are issues to be considered at the time of final hearing, and to that effect the writ petition has kept pending. Writ petition has been kept pending. Stop. In our opinion, the learned single judge has exercised discretion specifying the reasons, and we do not find any infirmity in the same. Accordingly, the appeals and the connected applications are dismissed. Stop. We have been informed that affidavits have already been exchanged by the parties in the
No, they have not filed a reply. We have filed our affidavit.
We'll affirm and we'll serve it today itself.
dismiss. There shall, however, be no order as to proceed.
My lord, I was praying for two things, subject to your lordship's permission. Number one is, my lord, kindly, my lord, if your lordships may kindly direct the learned single judge to expedite the hearing of the matter. And number two is, my lord, this is a newly opened, my lord, zoo. But at least, my lord, by giving him charge, at least we can, my lord, post them, my lord, keeping the transfer order in abeyance, because I have to run that also.
You tell that to the learned single judge. We have not gone into that.
No, if your lordships kindly permit us that. Because otherwise, it's a newly opened zoo. I won't get anybody over there.
Mr. Dotto, we have not said that. You can certainly approach the learned single judge. Yes.
Or some observation to expedite, my lord.
That the single judge herself has said that you come with the affidavits, I am fixing it up. September combined list, it was fished up. Now, therefore, due to extension, you mention and it will be done. I don't think that.
Very-
Yes, next. No, no, ওইটা রাখবে। রেখে দিও। ফেরত দেওয়ার। Yes, Passover. Yes, Miss Maya Mullik. Very, very good.
Lordship has already received a copy of the instruction, Lordship, I suppose. Direction
আমি ফ্রেম করেছি, আমি বলবো ওইটা তাহলেও বলতো। Yes, she has been recovered.
Yes, the victim girl has been recovered. She is in CWC. Lordship, the accused has been arrested, both the accused.
She ran away with whom?
She ran away with one
Horipodo.
Horipodo Mondol.
My lord, on last hearing, state mentioned that one accused was arrested. So who is this?
Both the accused has been arrested.
Your daughter will know with whom she went away.
No,
Your
my lord,
daughter will know.
my lord, before passing this order, police arrested one person. Before
Yes.
passing of this honorable court order,
Yes.
one person was arrested.
Right.
Initially, Rothin Kumar Mondol was arrested. He was, as per the complaint of the petitioner, he was one of the accused. Lordship, subsequently, the main accused, Horipodo Mondol, with whom the girl has fled away, he has been arrested and
Heard the learned advocate.
Yes, my lord,
appearing for
we
the
want to
petition.
mention that.
Give me a
Mondol-
Give me a copy of the report, Miller.
Which report?
The report submitted by the.
Oh, we are recording that in our order.
My lord, Rothin Mondol is frequently threatening and he is.
Acha, how many council will appear for one person? You are appearing in Mr. Chotra.
তুমি বলো আমি বসে পড়ছি।
Miss Maya Mullik, you are alleging you are being threatened. Have you lodged any complaint?
no.
তারপরে have you lodged any complaint?
Yes, ma'am, complaint law.
When?
ওই complaint টা দাও।
3rd October.
No, Lordship.
ওই দেখো কপি দেখো না।
Heard the learned advocates appearing for the respective party. We have been informed that the victim girl has already been recovered. Her statement under section 164 of
Has
the
been
code
recorded.
has been recorded, and she was
He has denied the medical examination.
no, first
No, no, no,
medical
no, no.
examination was
No,
not.
no, 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 no.
We are not commenting on that. Stop. কি বললে?
এই কপিটা কোথায়?
And she was produced before Child Welfare Committee bracket ছোট in short CWC, Purbo Mednipur, and is presently residing at Sister Nivedita Children Home for Girls, Godar. এরকম কোনো নাম আছে? Nivedita Children Home for Girls, Nando Kumar, Purbo Mednipur. Stop. Since the victim girl has let the written
Miller handed over the victim girl to the parents.
that he will go and ask from the CWC. Parent will go to CWC and ask for her. Since the victim girl let the as filed on behalf of the state as produced, let the report filed on behalf filed by the investigating officer as produced be kept on record. Since the victim girl has already been recovered, no further order is required to be passed in the present habeas corpus petition, and the same is accordingly disposed of. Pen drive button. Yes, next.
Much appreciated.
I'm for state, Lordship.
Yes, 2. Vicky. Hey, what is the matter?
Lordship,
Say.
I have not received the brief, but I have received the instructions, Lordship. After going through the instruction, it seems that there has been a matrimonial dispute. The petitioner is the husband, and the wife and the minor son has left the matrimonial house due to this matrimonial dispute, Lordship. Subsequently, on 9th of October, a complaint has been lodged by the wife, and after that, she has left the matrimonial house, Lordship.
Complaint has been 498A.
Yes, Lordship.
Now, this petitioner lodged any complaint?
Petitioner, Lordship, since I do not have the brief,
Okay.
Lordship, I do not have.
His complaint is at page 16 of the writ petition. 10th of, you ascertain whether you have registered any case or not. And what is the status of that? Come back tomorrow with that instruction.
Yes, I'll just come back.
Nobody appears, we will keep it after the vacation. Please obtain your instruction in the meantime.
Should I submit the report, Lordship, today or tomorrow?
No, we will record your presence.
Grateful, Lordship.
Your Lordship, yesterday I started my argument with the recapitulation of the fact that I moved an application before the learned tribunal below.
Pressing urgency. Any pressing urgency?
Yes, my lord, because the disciplinary proceedings they have already initiated. They are heading towards, and since due to pendency of these matters, since I have raised the issue of the passing of the charge sheet, so therefore I did not participate in the disciplinary proceedings. With the passage of time, if they will attain to finality, there would be any, they will prejudice my grievances. So the learned tribunal, my lord,
when is the next date fixed? Disciplinary proceedings.
Yesterday, your Lordship was pleased to direct upon the respondent to take the instruction when the date is fixed, my lord.
When is the next date fixed?
If the date, Mr. If the date.
My instruction, my lord, we do not, they have contacted with the vigilance cell. Our legal cell has contacted with the vigilance cell, but the exact date is not available with us.
No, why do we say if the date is sometimes in December, we will allow you to use a short affidavit and finally dispose it of. If the date is said, if date is in December, we can consider it on the basis of that.
Right now, my lord, he will be in a position.
Can you ascertain that, Mr. Gandhi?
Lordship, that date exactly I am not aware of, but if your Lordship comes into the factual matrix of.
No, that we will go. We are
Lordship, why
wanting
I am
to
saying
know.
is, he challenged the enter proceedings before the CAT. It continued in the
Then
CAT.
you submit.
Yes. But the snippets of the fact, valid. I'm not on.
It was the last date fixed, Mr.
Yes, what 11th of October 2023, which I'm having this particular office letter, by which I have been instructed to appear into that.
Take it to. Because in the tribunal there has been no exchange.
No,
your
the
argument
tribunal
is you are challenging quashing of the
charge sheet,
and in the face of such challenge they cannot proceed with the discipline. This is your case.
That is my case, and the tribunal has held since I need to go before the participate into that under 14.2 I need to give reply. Then after whatever the outcome of that particular proceedings, and then after being aggrieved.
So, Mr. Banerjee, you take this instruction and come back with that. If it is in December, we fix it on the prior to that and finish it up.
I don't have any issue, Mallet, because there is a no rebuttal on their side, Mallet, because this particular application has been dismissed in limine and the interim order has not been granted.
That is why we are saying they must be having something to say. We have to hear them.
Yes.
So we will give them a lot of opportunity to reply to this.
Yes, Mallet, I'm not standing in the way.
Certain and come back at 2 p.m. And if the date is somewhere else, then we will go in.
Lordship, then Lordship, keep it on Thursday. Tomorrow.
Thursday or Sunani have
It's very tough, Mallet, because
so that we can take instruction.
No, even yesterday, your lordship was candidly
Take a
directed to them.
telephonic call and get the instruction. Na?
Government brief, Lordship. It's a government brief. And the issue is with the DRI and the vigilance. This gentleman was involved in a fake export issue. So the entire,
We are not on merit.
so
sir.
now my disciplinary authority, it's not within my ambit. I can talk to up to my commissioner.
Then who is within
Yes, Lordship, my commissioner will talk. So
who
I
is
need
your commissioner?
Commissioner Bolpur and Commissioner not GST. He is now, it's now not GST.
Who is the disciplinary authority? Tell us.
Lordship,
It is Yagnik Baghal, Deputy Commissioner and Inquiring Authority. He is the person under you, na?
Yes,
Lordship.
correct.
So
He's
Mr. Banerjee, you have a greater hold.
Not
na?
just.
What will you appear?
It's posted, presently posted in this.
Lordship, then Lordship keep it.
Because
Lordship,
that well, after transfer,
Tomorrow-
the respondent number 2 become the officio functus because he has transferred to the North Zone. Now the entire charge sheet is before them. So
But sir, who is to tell us when is the next date?
Let me
You
take it.
cannot tell.
2 p.m. Then we are coming at
2 p.m. we shall try to ascertain it.
But ascertain it to that effect. Otherwise, we will be recording your words. Na? So take proper instruction that we have been informed that the next date is hearing is such and such. Then we can.
তোমার কাছে নেই, তুমি তো petitioner হলে। আমি তো এতে দেখো
Next date before CAT.
CAT এর তো
CAT
dismiss
এর
হয়ে
তো
গেছে।
CAT dismiss হয়ে
It has been dismissed।
11-10 এর পরে নেক্সট ডেট কি?
এটা জানি না। That
আমি
I
জানো
don't
না, তাই তো? আমি জানছি।
You make an endeavor to know 2 p.m. any problem?
No.
No,
আপনি তো একটাই উঠবেন। Come at 2 p.m. Mr. Banerjee with the instruction. Otherwise, we hear it out.
At 2 p.m. I was mixed matter in courtroom number 28.
Division bench and a single bench.
Division.
Division bench. Which bench?
Justice Bakshi.
Huh?
Justice Bakshi, 2 p.m.
Oh, আচ্ছা আচ্ছা। তাহলে you are before a senior judge then, huh? When can you come? Tell us.
3 p.m. করি?
At 3 o'clock, if your lordship permits.
I have to pilot.
একটা 2:30টার সময় কি ম্যাটার রেখেছি না?
Malad, my junior will be there. Whatever instructions are there, Malad, my
No, we will be recording your
Yes,
name na.
that is-
So your presence is necessary. You can just now have a call and come back.
I shall try.
A password next to that.
May I have the losses leave to mention one item?
Sir, we are not relieving our seat just now.
Malad, we are doing item number 5 before the Honorable Chief Justice. Now, this has been released on personal ground and
Which
Imme-
one?
Malad, the item number 5 before the Honorable Chief Justice bench.
Huh.
Malad, the matter was taken up. Malad, the Honorable Chief Justice bench has released the matter and the Honorable Chief Justice in administrative capacity has assigned the matter to your lordships. The writ petition is pending at 1 p.m. The Honorable Chief Justice has requested the other side to request the learned single judge not to take up the matter today so that the appeal can be taken up by your lordships at any point of time today. That's the urgency to your lordships. Well, kindly, Malad, this is just filed to
What is the subject matter?
subject matter, your lordships, in a criminal proceedings. I have been given, Malad, final report has been filed by the anti-fraud detective agency, Malad, releasing me. But in spite of that, giving several opportunities, the writ petitioner did not file any Naraji petition to that. On the contrary, after 1.5 years, they have filed a writ petition for de novo investigation. And the learned single judge has allowed it. So this is not permissible in law, my lord. This is permissible. He could have taken a petition before.
Why read, Mr.
That's my point, your lordships.
You are for the respondent.
I'm not a party even. And I have been started in Malad inquiry.
Step number 5 is Sunanda.
Exactly in the same matter, my lord.
You have challenged an order
Of the Honorable Single Judge in the writ
directing what?
directing CID to start investigation, file inquiry report immediately. And further process probably will be taken up by the learned single judge at 1 p.m. But because of the request, probably I hope the matter would not be taken up today.
We have not seen the assignment.
My
of
lord,
that.
your losses, this will come up within 5 or 10
আমরা
minutes,
জানি
my lord.
We have not seen the
Kindly,
assignment.
your losses.
পেয়েছো?
No, no, this will come up within, my lord, 10 to 5. Kindly direct, my lord, I will intimate your lordships officer. Kindly, my lord, take it up to, my lord, by publishing a supplementary
No,
list.
no, who is your other side?
No, I will intimate, everybody was present. Everybody knew about it. I will give the formal intimation to them.
We will hear it tomorrow. What is
But
the
tomorrow, your losses again, writ petition would be taken up in the morning.
Chief Justice has requested.
Not today. It was fixed at 1 p.m. But I have to follow this. I have to chase this, my lord. What am I to do, your lordships, kindly? It's so urgent. But file will come up within, my lord, 5 to 10 minutes, your lordships.
No, no. Because first 2 years is BA subject.
No, ultimately, that is BA-LLB now too.
Yes, now it has been done. So when we were students, it question came up in our mind that you will consider as law graduates, but not holding 2 degrees.
Now BA-LLB honors.
No, there was another problem at that time. If you are registered as a 3-year, you have to obtain registration of university. Now you cannot take dual registration. One for 3 years, one for 5.
Migration was there, my lord. If I change the university,
My brother will be rising at 1, come back.
no, I'm giving a
Get
notice to
hold of
come back.
any other side advocate, otherwise we will not publish the list.
I'll come.
On oral mentioning, we cannot. So yes, Jaco corrected.
My lord, I am appearing for evidence. Appearing for evidence,
Item number
12. Mr. Achin Kumar Mujumdar engaged courtroom 12. Kindly fix on 3 p.m.
a VRD code to fix matters at 2 p.m., 3 p.m., 3:30.
My lord, these, my lord, I beg to be, my lord, I am not getting.
কি বল কি কথা বলছি?
My lord, I appear on behalf of the respondent, my lord. My video has been turned down, my lord. Unfortunately, I'm in Port Blair, my lord. I seek your lordship's leave to, my lord, allow me.
We cannot hear you also. Both functions must operate, na? One to see and the other to hear. Who is your senior, madam?
Achin Kumar Mujumdar.
Where is he?
Courtroom 12 engaged.
What is the urgency? Pass over. Yes, পরের টা দেখো।
This is my application, madam.
My lord, in this matter, my lord, I am appearing on behalf of the Coal India, my lord, and I am led by learned counsel Shomit Chanel, my lord. He is in virtual.
We do not want you discuss with your friend. We are fed up with this adjournment business.
I am not praying for any adjournment, my lord.
You're not praying for
No,
My
my
lord,
lord.
I beg to appear on behalf of the answering respondents, my lord.
He is my senior, my lord. He is in virtual mode, my lord.
He's your senior.
My lord, he is in virtual mode, lordship.
We cannot see him, na? Oh, acha. Hannal,
My lord,
solution.
my lord.
কি অসুবিধা হচ্ছে?
I paper a writ petition challenging the notification issued by this Eastern Coalfield Limited.
Hmm.
That notification was challenged by the petition.
Notification was challenged. Challenged a notification.
Yes, ma'am.
Notification for what?
Notification for the promotional post, that is the selection through promotional post, that has to be taken. The examination will be held within few days, and thereafter the person, those who have been promoted, those who have been selected, they have been promoted. Against that,
Already promoted?
no, Manoj, that has not been, process has not been completed.
Let us understand, ma'am. There is a selection process started in which there
Application was filed. They have called for the application from the departmental employees, and as well
a promotion is on merit cum seniority.
non-executive to executive post.
Very good. That is pursuant to a test which is to be conducted.
Yes, madam.
Any merit test to be conducted?
Yes, ma'am.
When is that test?
I could not understand, my lord.
You are saying that you want promotion from one post to another.
Yes, ma'am.
You are not being considered.
Yes, no, not consider. Your lordship, kindly allow me to place my case. My lord, actually, we are the employees, the non-executive post in the Eastern Coalfield Limited. The notification was published by the Eastern Coalfield Limited. We invited the application from the non-executive post, from the non-executive employees to be promoted to the executive post.
My lord, I beg to be pardoned, my lord. My learned friend is making submissions on merit. He is on basis on the maintainability. I'm sorry, my lord. I'm sorry.
We have asked you to argue.
My lord, I'm sorry, my lord.
So don't disturb.
My lord, I'm extremely sorry.
Yes, that application was called for from the employees, from the departmental employees, and subject to conditions that they have been some experience. Otherwise, they will not be allowed to participate in the selection process. But we are the employees.
What is the selection process? Can you tell us? Any test is going to be conducted?
Yes, my lord.
When is that test scheduled?
I am not understanding. My lord, your lordship's words is not coming to me.
You cannot hear me.
To me, my
Microphone দিয়েছো নাকি? Yes.
Exam is not yet been declared.
So very good. That is what we wanted to learn. Now kindly come to the impugned order.
Yes, my lord. Your lordship, kindly come to the memo, my lord, that I have annexed in
4th October 2020.
Yes, my lord,
Please
that
place the
order was passed, and that order was passed by the largest single bench.
Place the order.
Yes,
Place
my lord.
the order.
Leave as prayed for by Mr. Court to file a supplementary affidavit is granted.
Who is Mr. Court?
I am.
You
No,
prayed
I am
for-
not prayed for. I am not prayed for. That is the main point. That the matter was taken up, your lordship.
Read it first. Will you read the order first?
My lord, I was appear.
Will you read the order first? Tell us what is the order.
In the supplementary affidavit, the names of the members of the petitioner will be brought on record. Furthermore, how the deponent has been authorized by the members to affirm the writ petition on their behalf will also be brought on record. Let the matter be appear further for consideration under the same heading motion on November 28, 2023. In the writ petition, I prayed for interim order. That interim order was not considered by the by our lordships, and the matter was sent for November. They will conduct the.
Is that you prayed for interim order and it was rejected.
Well,
Your prayer was to file a supplementary evidence.
That is the main point, but they will conduct the examination within the puja vacations.
Where you have said that?
Yes.
Where have you said that in the writ petition?
Yes, madam. My lord, your lordship, kindly come. In the writ petition, that is that I have stated in my read petition itself, my lord, that the a notification was published inviting application from the concerned employees.
Have you understood what
Yes,
we
my
have
lord. I have
asked?
understood, my lord. I am
Then
showing to your
please
lordship, my lord, your lordship.
make other submissions. We are asking you a point, you answered.
Yes, ma'am.
Where in paragraph, which paragraph you have stated that written examination will be held? And that is why you are wanting a stay. Go through your brief and come back. You are not ready with the matter.
No, I am ready, my lord, but
Then if you are
this
ready,
point,
tell
I have
us.
mentioned it. I have already mentioned in my read petition that they will be
All
further
right.
notification will be published and conducting the.
Yes, Mr. Chandan.
My lord, we raised a preliminary point, my lord, on
Forget about
maintainability.
preliminary point. You are conducting a selection process. Are you conducting any test?
Yes, my lord, we will conduct. We
When?
are already, we are, my lord, we will finalize the date. We are issuing the admit cards now. We are in the process of issuing admit cards.
When is the date fixed?
My lord, the admit cards will be issued from next week onwards. The process is already complete. The screening process is already complete. Now, my lord, there is, now we will issue the admit cards.
Difficulty is you do not answer our questions.
My lord, I will come.
That you have issued admit card when we are wanting a simple question.
My lord.
Are you conducting any written test?
We contemplate conducting. As of now, my lord, we have not given any date.
Very good. Then are you contemplating to give any date prior to reopening?
No, not now, my lord.
Not now.
Not now.
The test will not be held on the returnable date the court has directed.
28th.
28th.
28 November.
So by 28th November, there will be no further process for holding any examination.
But my lord, the process is going on. This I have to, my lord, admit before your lordship.
We are asking you whether you are issuing admit card must be for some examination.
Yes.
When is the examination scheduled? Is it
My
prior
lord,
to 28 or after 28?
my lord, that date, my lord, the department will fix when the, my lord, admit card process will be over.
To take that instruction.
My lord, we'll come back tomorrow.
Right? You come back tomorrow and tell us that when you have scheduled the date.
My lord.
I said, I'm grateful, your lordship.
Yes, Mr. Banerjee.
Lordship, I have taken instruction in the matter. We have to conclude it by 3rd of November because my 6 months time is overing within 3rd of November. From the date of appointment of the 3rd May. 3rd May was the date of appointment of the inquiry officer. CCA's rule says that I have to, this is the inquiry proceedings. After that,
we have asked you a simple question. We are not wanting justification from you. We are wanting to know when is the next date fixed.
Lordship, next date is not fixed, but the outer limit is 3rd November 2020.
Then we hear the matter.
Lordship.
You do one thing. You come back at 2 p.m. 2 p.m. we have another fixed matter. I don't know whether if per chance it is not taken up today, then it will be taken up tomorrow for considering this interim.
Okay.
If our fixed matter ও তো আসেনি তোমার কাছে ফাইল এসছে তা তুমি কিভাবে লিস্ট পাবলিশ করবে
Yes, my lord.
Tell us.
The facts, my lord, that
কোন copy? ওইটা দাও একটু listed ওই কত item number?
the order impugned has categorically stated my submission and what the fact before the court below, my lord. Kindly straight come to the impugned order, page 2.
পরের মামলা দিয়েছো, you have not given the correct file.
Item 7.
This is a mandamus appeal or order of tribunal. WPC. Vacation এসে গেছে না, মাথা ঠিক নেই।
Yes, my lord. File টা দিয়েছেন?
Yes, tell us the story. What is
Yes, the story is very simple, my lord. I was posted in a Petropol custom unit.
So you are dealing with a very simple story.
Yes, my lord. And there was the DRI investigated into Petropol. The few persons,
DRI is
Directorate of Revenue Intelligence.
You were appointed. You were.
I am superintendent posted in a Petropol custom unit, my lord.
Border.
Border. Bangladesh border.
Yes.
So when the DRA visited they summoned, and accordingly I received a WhatsApp message to attend the summon. I duly appeared, my lord. The allegation was pertaining to that there is a certain fake shipping bills has been created, and without any substance or material, the bills has been through, my lord. On such basis, my lord, they intercepted few contingent staff of by the DRI. Thereafter, it was truce period, my lord. I put on suspension. I just revoked my suspension during the passage of time.
DRI initiated any proceeding?
No, DRI cannot, my lord, because DRI at that point of time, DRI has initiated the proceeding. They issued the show cause notice.
No, that is what we are wanting.
Yes.
That was in connection with a contemplated proceeding.
No, that is not with the disciplinary proceedings. That is with regard to the separate proceedings under Section 24 of the Customs Act. So,
What does Section 20?
Section 24, my lord, if there is any prima facie cause, the 108 of the Custom Act and 124, they can issue SCN, that is called show cause notice. I replied both the notices, my lord. I replied to both the notices.
To come back at 2 p.m. 2 p.m. If we have that matter, then it will be taking some time. If we cannot reach, we will take it up tomorrow.
But tomorrow, my lord, top of the list, my lord, subject to your lordship's convenience. I beseech your lordship for that.
Yes, it will be there. We have not, if we cannot reach, we will make it.
Okay.
You will be here, you remind us. Yes, what is the,
My lord, may I have
where is your other side?
My lord, I have given notice.
No, notice will not serve. Where is your other side? Bring your other side.
My lord, I undertake
Sir,
that.
try to understand.
I understand, my lord.
Your contention is the Honorable Chief has passed an order.
Yes.
That file is not here, that order is not here. On that basis, how can we say that you publish it?
I tell your lordship, they were under the department was under the impression that they will get a few minutes more time, my lord. I have already indicated that the bench may rise at 1 p.m. My lord, they are taking steps. The letter, etc. Those have already been issued. My lord, I was personally there.
Unless you bring the other side, how can we say publish a supplementary list?
My lord, kindly take my undertaking that I'll immediately call and I'll again issue another email.
Yes, call the list.
My lord, again troubling your lordship, my lord, I am told the file has reached your lordship's court with the communication of assignment, my lord. My lord, we communicated the learned advocates of the writ petitioner and the state. We were there together in respect of another matter before the same honorable single bench. I personally communicated, and I am mentioning upon notice in writing. My lord, kindly my lord, it's a copy.
When have you served the notice upon them?
My lord, I served two notices, one at 12:45 for 1 p.m. mentioning and another at 1:15 for this 2 p.m. mentioning.
So it will be there tomorrow. Tomorrow in the list it will be there.
My lord, the matter,
Topic.
my lord, the matter has been deferred for 15 minutes. Matter may be taken up at 1.
The order, check up the order. Check up the order of you say something before chief and you say something here.
Not
first from the order. That matter has been deferred for 15 minutes. Why do you make such a?
My lord, before the honorable single bench. Before the honorable single bench, the matter has been deferred for 15 minutes.
It has been deferred for 15
My lord, it was fixed at 1 p.m. till my lord 1:40. Another matter was being taken up. The same matter where your lordship was pleased to pass an order.
The Hon'ble deferred. His lordship has.
But I'm not sure whether
I am
deferred.
also not sure because the Chief Justice in his
So
order
now I'm
has
told Mala that 2:15 this will be taken up.
1 p.m. fixed
how it's taken for.
কি বলবো my lord? আমি
You go and request the single judge that.
Mala, this is not. What should I say, Mala?
The Honorable Chief Justice request. There is nothing in the order.
No, Chief Justice requested the learned advocate for the petitioners to intimate the honorable judge not to take up the matter. Well, this is sufficient. This is,
Mr. Hon'ble, the problem is you notice they are not appearing. Suomoto, if we add it in the list just now, it does not sound well. Now, if you are on the other side, you can certainly come and
no,
say
I have given notice at least. Well, they knew that I will come up and mention it. Their presence, the honorable Chief Justice said, I'm a
পুরনো নোটিশটা কই দেখাও না লিখে দিই
In this matter, my lord, I am appearing for the appellant petitioner, my lord. Your lordship directed me, my lord, to inform
Mr. Dalal.
Kumar's Dalal, my lord, learned advocate, my lord, Today he has not come, my lord. I have been informed by telephone. He has been suffering from dengue fever. My lord.
Oh my God. Then who has been engaged?
Kumarer Dalal, my lord. Already I have talked to him.
If he is sick, how can we?
Yes,
take?
my lord.
So we keep it after vacation?
1 week after vacation. Then.
1 week after vacation? Yes, 1 week after.
Evidence service, my lord, be kept in the record.
No,
my
we
lord.
are not keeping that. It will be.
Well,
Uh,
evidence service that return.
like the affidavit of service, you serve intimate, it will be there on 1 week after vacation.
দুটো আছে।
28 It will be there on 28th.
28,
1
20,
week.
yes.
You wanted 1 week after vacation. কবে খুলছিলাম? 17 তারিখ, 16 তারিখ। 23 তারিখ, 23rd it will be there.
I'm grateful, my lord.
Yes, next. It will. পাসওয়ার্ড ছিল 12 সেই 13টা ডে আর কোনটা আছে ওইটা ওনাদেরটা কত আছে
My lord, under compelling circumstances, if your lordship kindly permits me to mention that lordship will kindly remember that appeal which was assigned to your lordship.
Sir, just now we have kept it tomorrow at the first.
No, not mine. Mine I had not pressed on the ground that the writ petition out of which the appeal arises was dismissed by the learned single judge. Now, my lord, it's very unfortunate. The learned advocate for the writ petitioner was present in court, who also said it's dismissed. Now, subsequent to that, we came to our notice. They filed a review application of that order. The review application was posted today for hearing, and just now
Review order of which order?
the writ petitions order of 4th of October, from which I have made that appeal.
Right.
The writ petition was subsequently dismissed, so I not pressed the appeal before your lordships.
Yes.
Now, my lord, subsequent to that, it appears that the writ petitioner filed an application for review. Review was mentioned, I believe, yesterday or day before yesterday, before the learned trial judge.
Without notice to you?
Yes.
Without
No, notice was given.
then
And review has been, my lord, the order has recalled today. Now, if the order is recalled, well, that order revives, from which my appeal, my lord, arises.
what is the review order? What his lordship has said?
His lordship has, my lord, dismissed the writ petition with cost of
I
one.
understand if the order has been recalled,
Lordship,
order of dismissal of the writ petition has been
recalled,
recalled.
recalled. Order is not in the server. Just now it has been passed.
So now the writ petition has again
Yes.
become alive.
Absolutely.
So you take steps.
No, therefore, my appeal, which was assigned to your lordships, which I had not pressed on the ground that writ petition stood dismissed, which they also said yes. Now, my lord, since the writ petition is revived,
You take steps. You know what steps are to be taken. Yes, call the take the file to the. Hey, call this man. The quarter fix this.
7 mandated.
Your other everybody is here.
Lordship, I will be.
Where is Mr. Bennett?
He is in court 28 as he informed your lordship.
To let him start.
Yes,
Yes,
yes.
yes. May I, lordship?
আপনি আমার সেটা initiated a proceeding under sections 24, you
Yes, sir.
said.
My lord, kindly come to page 2 itself. On 11/12/2018,
11/12. Yes.
DRI visited the Petropol checkpost ballot, and they summoned 4 officials who were related with the issuance of the bill ballot. I was not on that. Then after my lord, on 19/12/2018, I was summoned to appear before the DRI. I duly appeared. On a very first day, when the DRI was
Just a moment.
Yes,
This 11/12/2018, this 19/12/2018 show cause was
Yes.
passed in a proceeding under section
no, it was just summoned under section 108 of the Custom Act, my lord.
section 108. Very good.
I duly appeared, my lord. Then after, at the time when the first 4 officials and the certain
What is your Customs Act? Do you have the
No, the
Customs
Custom Act is not here, my lord. Because I'm not related with the Custom Act, my lord. My
I'm sorry, my lord, I have only
Yes.
one.
Doesn't.
114 is marked.
That's give evidence. In respect of what? In any inquiry. Achha. This inquiry which the DRI was making, that is under which section?
It was basically valid under 2 sections. The first is 108 when they issued the show cause, and the second 124, 124 is the summon, and 124 is the issuance of the show cause. I participated in both the proceedings, valid. I appeared and duly, whatever the show cause, I replied valid. The main issue derived from that particular proceedings, valid, the contingent staff who were working as a custom house agent made my name during the process of the summon, valid. I prayed to the DRI.
So your name came on the basis of other persons.
Other persons who are the contingent staff. I prayed, very good, if they have taken my name.
You appeared and you gave your show cause.
Yes. And I prayed for the cross-examination of those 4 persons who have taken my name. That opportunity was not given to me, Marit. That opportunity was never given to me to cross-examine those persons who have taken my name.
Why, under which provision?
Marit?
Under which provision you wanted to exercise that right?
Because
Section 108 is something about summoning someone to produce certain documents.
Kindly come to Marit, because yes, which section, Marit? This particular third-party evidence, when your lordship will go into the merit of this application, your lordship will find the custom department is itself having the circular by saying that once you are issuing any departmental inquiry under Rule 14, then these third-party persons, those who are taking name, must be cross-examined and to make out the watertight case. And those persons have to be under clause appendix 4 of the witness, so that I may get an opportunity to defend myself, my lord. That particular circular.
The regular disciplinary.
Yes. The circular is itself in a part and parcel of the order impugned, my lord. I have stressed before the tribunal that there is a circular. They said that this is not.
That is a defect. That is a defect which they will suffer. This, what you are saying, that if you don't call those persons, I will be prejudiced because I cannot cross-examine them.
Yes.
But without their evidence, can they establish the guilt against you?
But my lord, they are doing so.
So when they are doing so, that becomes the subject matter of the main disciplinary proceeding.
And
that you will challenge, that is covered under this.
Yes, my lord. But the point is this: the 2 points I have to. The first is the vagueness of the charge.
He will keep those points open. What is the problem?
No, nothing, no problem, my lord. My issue is only this, my lord. If any persons who have named my name, if I would not get a cross-examination in a DRI, in a proceedings under Custom Act, then after, my lord, if a disciplinary proceedings, if they have not made witness in a annexure 4, but their reliance of their statement has taken into annexure 3 of the CCS conduct rule, my lord, because annexure 3 is the RUT under which your proceedings are going ahead. These 3 persons witness has taken into consideration their statement, my lord. Their statement has taken into consideration, but annexure 4, they are not mentioned that. Only the 2 DRA officials are there. So literally, my lord, if I participated, then I am not getting any opportunity to defend those persons or to cross-examine those persons who have taken my name, my lord. That was the consideration which I have played before the tribunal. Even in the tribunal, my lord, kindly sees the official circular, my lord, that is part and parcel of this order impugned, my lord. Kindly come to page 9, what the circular speaks about. That is their departmental circular, my lord. Page 9 of the order impugned.
Mr. Bhushan, why you are challenging the charge sheet? You are challenging the charge sheet on a ground that it is defective, since 3 persons have not been called as witness by the authority.
And this charge is completely vague charge sheet because that is at the instance of the DRA officers, my lord. There's no definite article of charges. Kindly come to charge sheet itself, my lord. It is completely the same story which DRI has taken because under section 14 of.
You have understood your primary grievance is that you are not calling the persons on whose statement my name has come.
Yes.
That is an inadmissible part of the evidence.
Yes.
Co-accused statement does not give direct admission.
Yes.
So when their names have been incorporated, their names have not been called as witnesses.
No.
So they will face the problem. You will appear in the proceeding. You will say that the statement which you are relying upon RUD.
Yes.
You have to prove that.
Yes.
So you have to call that person on whose statement you are making.
But yes, my lord.
You are at 2 stages. You have challenged the charge sheet primarily on this ground.
That is
now,
the
what
proof.
stay you are wanting? You are wanting that don't proceed with the disciplinary proceeding. We will leave all points open for you. How you are prejudiced, Mr. Musa?
Because I am prejudiced, my lord, because this particular charge sheet is itself a way, because the disciplinary authority has not applied his mind. He acted on the basis of the entire story of the DRI.
Mr. Bhushan, that is subject to be proved. Their prosecution case is, I have stolen money.
Yes.
So they have to prove that. How they will prove? Your contention is that you are making that allegation on the basis of some person's statement who have not been called as a list of witness in your matter.
Yes, that is there, my lord.
So their proceeding fails. If that happens, your proceeding
My lord,
fails.
your lordship, since your lordship is well acquainted with the service matter, my lord. The one issue, my lord, even if the article of charges would not be proved, the disciplinary authority is having power to put a disagreement note, my lord, and I can put into the civil death, my lord. The disciplinary authority has power to disagreement all the findings of the article of charges, even after we got the scot-free for the
crossing the bridge before it has come. You are crossing the bridge before it has.
But, my lord, since there is a departmental circular, my lord, though it is not a statutory nature, but the principles of occupied field will operate.
So your contention is charge sheet on its own is not sustainable.
Not sustainable.
Show us that.
Yes, my lord.
What was your challenge and what is the finding of the tribe?
Yes, my lord. Kindly come to page 9.
Charge sheet stand করতে পারবে না কখন?
Kindly come to page 9 of the order impugned, my lord. Para 4.
Order impugned.
Para 4. This is the substance which I am having, my lord. Learned counsel for the applicant submit that the charge sheet dated 3/1/23, Annexure 7 is a vague, baseless, and not in consonance with the circular issued by the department, and the charges level against him are based on the statement recorded by third person. By referring the instruction guidelines contained in letter dated 24/2/2011, Annexure A8, issued by the Ministry of Finance, Department of Revenue, Central Board of Indirect Taxes, New Delhi, with regard to the consideration of the statement recorded earlier in preliminary inquiry or under Custom Act 1962, as well instruction guidelines contained in para 4 of the letter dated 8/1/2020, regarding drafting of the charge sheet, which stipulates, as per the ministry letter dated such and such dated 24/2011, no statement recorded during investigation can be used against the CO in the inquiry unless the person is made a witness in Annexure 4 and is examined before the inquiry authority. It is critical that the list of prosecution witness is carefully scrutinized, finalized, and listed so as to make the watertight case and ensure that the charges can be successfully established. Learned counsel would argue that in the present case, the allegation leveled against the applicant in a memorandum are based on the statement recorded by DRI of some other persons. However, in a charge memorandum, the said person have not been cited as a prosecution witness by the disciplinary authority, thereby failed to adhere the procedure laid down in their own circular guidelines dated 8/1/2020 while framing the charges against the applicant herein. Therefore, the impugned charges memorandum dated 3/1/23 is issued contrary to the instruction guidelines contained in circular 8/120, and the same is required to be passed and set aside.
What is the finding of the tribunal?
Yes,
on
Maharaj.
this point?
Finding of the tribunal, that is interesting. Kindly come to impugn order, page 15, para 10. I harp on that issue. If this is the departmental circular, you cannot go beyond that.
Yes.
Then calmly come to page 10, page 15, para 10. It is apt to mention that DA proposed to hold an inquiry against the applicant herein under Rule 14 of the CCS Rules 1965, has drawn up the substance of imputation of the misconduct into different distinct article of charges and a statement of the imputation of misconduct along with the statement of all relevant facts and a list of documents as well as the list of witness for whom the article of charges are to be sustained. Since the DA has followed the provision of the statutory rules for issuance of the charge memorandum, it cannot be said that the impugned charge memorandum suffers from any legal infirmity. Therefore, the submission of the application is not acceptable. At this stage, it is also required to mention
There is no discussion as regards the circular.
nothing. I'm coming on. Kindly come to page, just two paragraph, my lord. Kindly come to page para 11. At this stage, it is also required to be mentioned that in terms of the provisions of the sub-rule 4B of the Rule 14 of the CCA rules, the CO is the applicant herein was given opportunity to submit in defense. It is established fact, valid. If I could have participated, yes, submit his defense, including any procedural lacuna in issuance of the charge memorandum. However, without exhausting the said remedy available to the applicant under the statutory rules itself, the applicant has rushed to this tribunal. Learned counsel for the respondent is correct in his submission that as per section 20 of the Administrative Tribunal Act 1985,
Administrative Tribunal Act.
Tribunal Act 1985, the applicant being the government employee should have first exhausted the remedies available under the rules, and in absence of it, the application should not be entertained at the same being premature. We are in argument with the said submission of the respondent. Then after Mallet 12, in view of the above discussion, the applicant is premature, and at this stage, we are not inclined to interfere with the disciplinary proceedings as proposed against the applicant by impugned charge memorandum dated 1/3/2023. The respondents had completed the disciplinary proceedings explicitly in accordance with the extant rules as well as the terms of principles of natural justice. Accordingly, the OA stand dismissed, and admin stage, we make it clear that we have not expressed any opinion of the alleged charge as level against the applicant in the impugned charge memorandum. No,
It was 14.
Rule 14.
CCS rules.
This is the yellow mark.
Code B is not there.
4B is there, Malet, because it is
Code is there.
14, Malet, 14.
Yes, 14, procedure for imposing major penalties.
4B of the Rule 14.
Yes, Rule 14 is procedure for imposing major penalties.
Yes.
Where is 4B?
4B within that, Malet, because that is a sub-para under Rule 14, Malet.
Okay, দেখো কোথায় 4B আছে।
3B, 5B.
It should be 5B, Malet. It should be, because there is no subsection under 4. So that it, because 5B is containing it our case, Malet. Proposition says so. ঠিক আছে, I know that. We are on an extreme stage.
You did not file any reply.
No, my lord.
The charge sheet.
No, because I was during the proceedings, I was in tribunal, and then after I challenged that order. And 20, my lord, if your lordship will see section 20.
Challenge which order?
No, I challenged the tribunal's order before here.
No, when was the notice given to you for reply? When was the day?
No, charge sheet date. Yes.
What is the date of the
The
charge?
charge sheet issued on 3/1/2023, my lord, at page annexure P7, my lord, page 62.
Page
Within-
62.
Yes. Application paper.
This was in 2023.
23, my lord,
Your-
3/1/23.
Your DRI summons us one.
DRI summoned in 18, my lord. After 3.5 years, the DRI issued the so cause, and then even after passing of 1.5 years from that time,
Now, after you file the show cause, what happened? What DRI did?
nothing. Nothing,
was
because I after the DRI so called ballot, I preferred an application before the learned tribunal by saying that they not put impediment on my promotion as well as the regulation of the suspension period. The learned tribunal in other OA
suspended.
Yes,
Suspended in connection with
in
what?
connection with that particular.
DRI proceeding.
Yes,
That DRI proceeding is under which provision? Customs Act, under which provision of Customs Act?
Section 124 of the Customs Act, DRI has issued the show cause notice. The show cause notice is independent proceeding and the departmental proceeding is independent proceeding.
No, the show cause is not on the basis of any commencement of proceeding.
No.
Only show
The
cause.
show cause is on the basis of the infractions done under the Customs Act.
Right. Now, if he has replied to that, what is the next stage?
He has already replied to the show cause notice and the show cause is under the adjudication stage.
That adjudication is conferred under which section?
Under section 124, the show cause has been issued under section 122 of the Customs Act. The adjudication is going.
Show cause is under 120.
Section 124 of the Customs Act.
Very good. Now then.
Now the petition has finally replied to the said show cause notice.
Right.
It is now under the adjudication stage, which is pending.
Now, after adjudication, order is passed under which section?
Under section 114, it is for penalty or for confiscation of goods. It will be passed accordingly that in
114.
114 is for penalty or for confiscation. Because the show cause notice has not been annexed in this instant petition.
Now, let us see what penalty can.
Your Lordship kindly takes the trouble to come to paragraph 41 of the petition itself. In paragraph 41, it has been stated.
Paragraph 41.
Paragraph 41, page 27.
Who has said it?
The petition has stated about these proceedings.
Now, what did he? What were the goods? What was the allegation? Shuka's allegation was what? What he has done?
About his complicity in the fake exports.
Complicity in fake exports. So monetary gain was there. Exports pertaining to?
Pertaining to one of the export goods, which I do not have those details with me right now because the show cause has not been annexed to the.
You are appearing for?
I'm appearing for DR.
Very. Yes.
Yes, Malik. And the second point which I submitted, Malik, the section 20 under which the learned tribunal has discussed, that is
just total export incentive is refund. Fund of tobacco says against those 33 consignments. 9,75,000. Mr. Bhushan,
No, my lord. So I am only harping on the two.
who were the three persons?
Yes, my lord.
Who was from the list, their names were
Yes,
not
yes, yes, my lord. Kindly come to page 66 of the RUD.
Yes.
Kindly come to point number 8, 9, and 10. These are the statements.
8, 9, and 10. Very good. And their names are not there.
And kindly come to next pilot article annexure 4.
Where is the circular which was quoted by?
Yes, kindly come to page 69, your lordship, para 5, which I was harping upon.
You were suspended.
Yes, that point of time, and suspension was revoked because the tribunal passed an order.
Point of time means 2018 when the DRI investigation was on. You were suspended.
Yes, at that point of time I was suspended.
So that was revoked.
They were revoked because the tribunal has categorically stated, if you do not find any substance, then you revoke your suspension. They could not find any substance at that point of time. And this particular charge sheet.
No, when did tribunal say so?
Tribunal said so in order, that I have stated in that.
What you are showing in page 69.
69, I was showing the pertinent part of the circular issued by the Ministry of Finance.
It is clarified.
It is clarified,
Where is that you have marked?
Kindly 71, your lordship. Kindly 69, your lordship, first.
You said 69.
69, para 5. What is the instruction with regard to any third party complaint? Kindly also come to page 71, your lordship.
Any general proposition of full opportunity has no evidence. Customs statement of officer is admissible. Statement recorded by itself. Customs are admissible. This is an article.
Kindly come to page 71 also. 71. This is the reiteration of the pertinent annexure again in 2020 as a guiding principles pertaining to these cases are concerned, my lord.
71.
71, para Roman small 1/4. Here's the depiction of the 24 to 2011 letters. And again, it is a reiteration of the same scrupulous observation of the procedure. And I argued, my lord, since they are saying it is not stereo, I specifically stated this is the principles or occupied field will operate. Because if there is no statutory substance in that, at least this particular circulars are apparent on the face of the record. So therefore, they cannot ignore. Because that is the direction passed by the apex body and it need to be look into the consideration by the disciplinary authority. And also, my lord, in section 14 of the rule 14 of the CCS rule is of the opinion. The disciplinary authority has to perceive the notion on the basis of its own opinion. They cannot dictate on the basis of DRI dictum. And here, my lord, that is the case which I made out before the tribunal. And the section 20 is completely altogether a different remedy, my lord.
This is what my brother is asking.
Yes, my
Now tell me one
my
thing.
lord.
The officers of the customs, their evidence is admissible, subject to cross-examination, which is if you want to get the evidence admissible in the disciplinary proceeding, there has to have some opportunity to the delinquent officer for cross-examination.
Exactly, ma'am.
If it was not done,
Yes, ma'am.
if it is done in the breach of that provision,
Yes.
it will inure to your benefit only.
It is there, ballot, but your lordship, because see, why I'm charged, why I filed this application, ballot, because once, even if I participated, the inquiry officer will make me scot-free from all the charges. The disciplinary authority is having power to disagreement note, ballot, and they can in limine dismiss, even though you are the inquiry officer has put you the scot-free, but I, being the disciplinary authority, has power to exercise my discretion to disagreement note, and accordingly you have been dismissed. So basically, and the major penalty charge sheet, ballot, kindly sees.
How that will, that against that your revenue, your available, your opportunity will be open.
That is the only ballot, the representation. You know, your lordship is knowing better than me. That is what that dealt with the representation of the disagreement note, ballot. So basically, if there is a lacuna from their side, ballot, they could have put into those persons in a list of witness. They could have put those witnesses in article annexure 4, but they did not. Neither they provide with the opportunity to cross-examine. It means their statement is being taken to sacrosanct, and I shall be framed on that basis, ma'am.
Where is that suspension remark? You said that was
Yes.
tribunal said.
Yes.
You are suspended in connection
Yes,
with
yes.
contemplation of
Yes,
the proceeding.
No.
Oh, in the DRI.
Yes, after during at the time of the initiation of disciplinary proceedings, I was not suspended, ballot. At the prior to that phase, ballot, I was suspended.
That was again revoked
That was again revoked
by the authority.
by the authority.
And now you are which post you are working?
I'm working the superintendent, ballot, and due to pendency of this proceedings, ballot, I have lost 3 opportunity to become the assistant commissioner. Because as your lordship knows, the judicial and the prosecution or the departmental proceedings pending, I shall not be promoted. And today the Prem Shankar Bali matters are considering for the completion of the inquiry proceedings, ballot, but it was never followed. Lastly, ultimately in a the CCS rules inducted, and the disciplinary proceedings now they are considering to complete within 6 months. Earlier it was 4 years, 5 years, 6 years, and ultimately they are put on death for the want of the promotion, etc. ballot. If they could have substance.
This one is alarming, Mr. Bhushan. You
Ballot.
have been involved in loss of money.
Ballot. If your lordship says so, kindly come to the charge sheet, ballot.
Any proceeding under PC Act?
Yes, no, nothing, nothing.
That's it.
Kindly come to pay charge sheet. I'm harping on those points only where they have stated. Kindly come to Article 2 of page 64. It deals with Article 2 where the statement of imputation of misconduct is there. Kindly come to para 4. If they could have made out the separate case para, I would be delighted to argue the matter. Kindly come to page para 4. Sri Surjit Sarnkar, who clears goods and Petropol LCS using the custom broker license of the Global Exim Logistics, submitted that he got the overmentioned 3 S-bills processed at Petropol LCS with active help of Sri Chakraborty Banerjee. Superintendent of the custom, such and such Sri Sarnkar also claimed to have paid money to Sri Banerjee through his staff Sri Shubhankar Pal in lieu of the getting those S-bill processed by the custom on paper only. Sri Shubhankar Pal, a staff working under Sri Sujit Sarnkar and Sri Arjun Adhikari, a contingent staff of Petropol LCS, corroborated the statement of Sri Sujit Sarnkar in their voluntary statement recorded under Section 108 of the Custom Act 1962, my lord. Then after, kindly come to page 65. Para 6. After completion of investigation. Yes, ballot. 6 ballot. It is a sketchy detail. Just para 6 ballot. Kindly go to the last 2 lines, ballot. Inspector along with Sri Chakraborty Banerjee, Superintendent of Custom, were also mentioned in involved in the processing of those S-bill for export without physical export goods. Para 7 kindly. Sri Chakraborty Banerjee in his version dated 22/7/22 inter alia submitted that the submission made by Sri Sujit Sarnkar, Sri Adhikari and Shubhankar Pal about his involvement in the case and paying money to him for such illegal work are a baseless and a false. He denied to have facilitated and processing the S-bill without physical export of the goods. 8. But the version of Sri Chakraborty Banerjee appears to not acceptable.
Yes, Mr.
So it is that on the basis of that
Take
fact.
yours. Yes. Any other, we cut it short?
No.
Any
I have-
other?
I rest my case, my lord.
First point which I was going to argue before this matter, Lordship has already taken a point that if it is a lacuna in my memorandum of charges, for that my client is going to suffer. Now, Lordship, kindly turn to page 63.
The tribunal decided the matter with reply rejoinder? No.
No, nothing. At the very admission stage, because the
Admission
yes,
stage.
on that very day.
Yes.
Now, Lordship, kindly turn to page 63.
It's 63.
3. And then, Lordship, we will again see the one paragraph which my learned friend has shown. 63 is the charge.
No, we are not on that. What is your stand pertaining to alleged violation of your circular?
Lordship, the violation of the circular is here. It gives, if I want to rely on someone's statement, I have to give in the evidence. If I do not give that in evidence, of course I cannot do it. It's a very basic principle of law.
Right. But
Now, Lordship, then Lordship, it might so happen, I am relying on a piece of a document, but may not be exhibited. It will be marks for identification. It might be a persuasive act.
that Mr. Banerjee is a thing which will happen in future. You are right that you will ultimately suffer if you are not in a position to prove that.
Lordship,
Because I put that question.
Lordship.
But
Now,
today, Mr. Banerjee, if you are allowed to proceed on this presumption that if it so happens in the time of subsequent proceeding, I will say I will not rely on that statement.
now, Lordship, thing is,
That is a presumption.
no, Lordship. What I'm saying is, now kindly see page 63. What are the charges I am bringing against him?
No, we are not on the charge.
I might not require that statement. That statement might be my source.
So then you omit those three statements.
No, Lordship, then I am coming. I have forwarded him those. I have not suppressed those. Annexure F to it, I supplied him. Now, if he wants to
Mr.
cross,
Banerjee, you are saying that if I have included those statements, I have given copies, but I am not calling them as witness. If you want to call, you make the prayer before the inquiry authority.
that's
Inquiry authority will reject such prayer.
then Lordship, then Lordship, if
Then why should we allow such a faulty proceeding to continue?
absolutely all right. Lordship, kindly come to page 63. Then.
63.
Lordship, Lordship, if we look into the angle of 120B or 34, then Lordship, the statement of a co-accused and cross-examination is required. If it is from 30,
Have you cited these three persons who accused charges?
need not to, because
No.
they are not in my department.
You were basically relying on the statement of those three persons whom this gentleman was not given any opportunity to cross-examine. Very well. It can be decided at the end of the
Lordship.
proceeding.
Lordship.
But how could you maintain this proceeding?
That's what I'm saying.
without
That's what I'm saying. Lordship, let us think once. That is a document from a collateral proceedings.
This is not document.
No,
You were
Lords,
relying
that's
on
not
the
my
statement.
basis. No, that's not my basis of my charge sheet. Kindly see page 63 once. And then, Lordship, we will go into that. Page 63, Mr. Orkoprabha Banerjee failed to maintain absolute integrity. What are the charges I am trying to prove against
We
him?
are not on merit of charges. We are on the issue of procedural propriety.
That's what I'm saying. That document is only a collateral proceedings document I am placing in this. But my charges is completely different. What my learned friend is trying.
Different.
Lordship.
Is pertaining to that incident which happened.
Incident may be same.
That DRI has called, so cause notice given. You are
Incident may be same. Lordship, we will try to.
In respect of fiscal penalty against the hiring accused, including the officers involved. This is not relating to the inquiry proceeding. Of
Right.
disciplinary.
Shut up. Now, Lordship, what?
a buddhi dikhche abar.
Supplementing.
Lordship, what we will try to demonstrate before your Lordship is, Lordship, the criminal proceedings is with regard to the penal provision against whoever involved in the offense. And the consequences is the fiscal consequences. Might be my officer, might be outsider. We can confiscate the good, customs can confiscate the good, customs can release the good with penalty. That is one part. Now, when this incident happened, then from reading the collateral proceedings document, we found this gentleman who was the superintendent at that point of time, he has done certain wrong. What are those wrong? He failed to maintain absolute integrity, failed to maintain devotion in duty. It might so happen that
the basis of such inference, the basis of such inference.
Inference is there. No. Lordship, the inference is there is a false export. That's the inference. It's not the inference that 3 men take his name.
Subject to correction. Basic document is relying upon the statement of one Swarnokar,
No.
who claims to have given
No,
money.
no. I will not go by that. No, I will not go by that.
And
That's
you
not the
are
case.
The inquiring authority, Mr. Banerjee, leave that duty to him.
That's what I'm saying.
You are not the inquiring
But
authority.
I'm trying to look into this matter from an angle. It's not like that someone has taken his name and under 120B or 34, I'm calling him. Their lordship is correct, then he has to be co-accused, has to be cross-examined. Lordship, here what I'm saying is,
He is not the inquiry authority.
Yes, Mr. Senior Banerjee, what do you say? File your opposition, don't proceed with the disciplinary proceeding.
Lordship, allow me.
One thing, Malad, over here, your lordship is referring to page 56, where he claims that some persons have not been given for cross-examination. Now, over here, this page 56 of your lordship's brief, which has been addressed to the DRI.
12th of April.
Yes. Now, kindly note this letter. This is in connection with the separate proceedings initiated by the DRI and the Customs Authority against the exporters and the importers involved in such transactions. Now, over here, he has been an intermediary. Why? Because he has been an agent who has camouflaged or manipulated the documents in facilitating the exports or the imports and thereby resulting in government loss. Now, this proceedings is initiated under the Customs Act. Now, this is an information. Now, what the DRI has made an investigation, DRI has found the involvement of some of the officers. Now, this is an information to the department to proceed in accordance with law under the CCS rules. Now, over here, my proceedings under the CCS rules is an independent cause of action based on the evidence which the department has got regarding the documents fabrication.
Right.
Now, this fabrication, whether it was done in his official duty, for that the charge sheet has been given to him.
Why you are relying upon their statement? If the statement goes, Mr. Banerjee, what remains in the proceeding?
Now, the documents, his documents.
That we will consider.
Now,
But
the
if we
statements,
just-
now the statements over here is not before the inquiry officer. It was before the DRI. Has he made a prayer that it has been refused, that he wants the cross-examination or the statements to be relied upon before
That
the
is
inquiry?
his whole case.
But where is his letter?
Says that you have included their statements on RUD, but you have not cited them as witnesses. That is his whole case.
Yes, now Malad, over here, where, that is his whole case is depending upon the statements which has been given in a collateral proceedings.
He is not even, you are.
Yes, in a collateral proceedings.
Right.
Now, if he wants, it is open for him to ask before the inquiry officer that you are relying upon this statement, you give me cross-examination.
How can he? In that case, he has to summon the witness. He has to again tell the inquiry officer.
Yes, now
"See,
if you do not rely, it will be reliance or non-reliance. The merits of the reliance and non-reliability, your lordship is now adjudging.
Now, Mr. Banerjee, one thing is there, that is that today, suppose your proceeding continues and it enters into the rigmarole that who is to call the witness. We will decide that. If we say that no witnesses are required, finally decide.
Yes, my lord. Over
And if
here,
not. But if the proceeding continues, Mr. Banerjee, nothing remains.
Ma-
We are fixing up a returnable date. We will hear it on that date. And till such time, do not proceed with the disciplinary.
Lordship, 2 minutes.
Abar ki hoche?
No, Lordship, 2 minutes. For my satisfaction, kindly Kindly take a look of page 63 and then Lordship pass the order.
দেখেছি basic
And also the first part of the.
Now, Lordship, page 63, Orko Prabha Banerjee failed to perform discharge his duty with the highest degree of professionalism and dictated to the best of his ability. That is what I'm going to adjudicate by IO. So that has got, this is what I'm trying to my learned friend, Mr. Banerjee also submitted, that Lordship, we are always thinking that evidence in the matter is the statement of that matter.
It is the original application.
Well,
Totally unexplained.
no, because well, since it was not pleading was not exchange mallet, so therefore I am totally on a very spot law point mallet. This is the application. Excuse me.
So Lordship, today we will try to demonstrate that his inquiry is limited to his official duty dereliction. If your Lordship looks into this, now Lordship, I may get this information from Mr. X, Y, or from my internal audit even. It is nothing to do with that criminal act. Now Lordship is, now Lordship, if your Lordship kindly looks into,
Yes, Mr. Banerjee. Ashok, the present appeal has been preferred, challenging and order dated 11th of April 2023, by which the original application being way number 350/326/2023 was dismissed at the admission stage. The order challenging an order dated past in an original application being such and such was dismissed at the admission stage. Records reveal that the original application was filed by the applicant stroke petitioner hearing, challenging the charge sheet dated
3/1/2023.
3/1/2023 issued by the respondent number
2.
Issued by the respondent number 2. Right? No, was dismissed at the original. This the said original application was preferred, challenging a charge sheet dated such and such issued by the respondent. Charge sheet dated such and such issued by the respondent number 2. Mr. Bhushan, learned advocate appearing for the petitioner, submits that though it was specifically argued by the petitioner that the charge sheet was vague and baseless. Well, that the charge sheet was not in consonance with the circulars dated 24th February 2011. And which are the two circulars?
Yes, Mallet. That is the 21.
One is 8/1/2020.
Yes. Yes, Mallet. 8/1/2020. Yes. The two.
কি লিখলে? Was not in consonance with the circulars dated 8th January 2020 and 3rd January 2023 issued by the department. Dated at the learned tribunal glossed over the said issue and did not return any finding on the same. Stop. In support of such contention, stop. He further argues, no, drawing our attention to annexure Roman 3 and annexure Roman 4 of the charge sheet. Mr. Bhushan argues that though the proceeding was based upon statements of one Sri Sujit Swarnokar, statements of Sujit Swarnokar, Shubhankar Pal, and Arjun Adhikari. The said persons were not cited as witnesses. In their absence, the petitioner would be deprived of the opportunity to cross-examine. Yes, sir. Due to non-inclusion of the said witnesses, the charge sheet itself becomes vague and baseless. Per contra, Mr. Senior Banerjee learned advocate appearing for the respondent number. You are Mr. Senior Banerjee for which respondent?
For respondent number.
Junior take
আচ্ছা,
you are appearing for 2, na? You are for
Bolpur. He is appearing for Bolpur, respondent number 2, and I am appearing for respondent number 5. And my learned friend, Mr. Dey, is appearing for number 3.
Next paragraph. Banerjee learned advocate appearing for the respondent number 2 submits.
My lord, kindly make it SS Banerjee and BP Banerjee.
Mr. SS Banerjee learned advocate appearing for the respondent number 2 submits that all the points agitated by the petitioner in the present application would be considered by the
No, Lordship, I took 2 points. All the point he agitated here cannot be looked into in view of section 14, rule 14(5)(b), because he has not given a defense. Unless you give a defense, the question of examination, cross-exam do not. This is one point. And the second point I said.
No, per contra, Mr. SS Banerjee learned advocate appearing for the respondent submits that the petitioner has not filed any reply to the charge sheet, though called upon, by incorporating the issues urged in the present petition. As no such reply has been furnished, the learned tribunal has rightly rejected the application on the ground of non-exhaustion of the remedy.
I did not take that. I said once you have not given a objection or a defense, you are not entitled to raise any dispute. First you have to dispute, then you have to cross-examine.
Has not.
Has right rejected the application?
No. So, per contra, Mr.
You have non-suited yourself.
Please listen.
Like,
as no such reply has been furnished.
No. Mr. Banerjee learned
the petitioner has not filed any reply to the charge sheet.
Reply to though called up. By incorporating the contentions as urged in the present petition. All right. Next, what is your next submission?
Next is page 63. Lordship, the document which I relied, I have supplied. Now, how I will prove the document is my list of witnesses. But the cause of action, what I am going to prove, has got nothing to do with this statement itself. That's an ancillary collateral proceedings I am reading.
You want to record that submission, think about that.
Then it is, moment Lordship has said, and then I think it is faulty.
Think about that. If you record that submission, it will be your responsibility.
Then Lordships may mold that submission like this.
We have record. Next, Mr. BP Banerjee learned advocate appearing for the respondent.
Then Lordship kindly do not record, because maybe my intellectuality.
I have that
my intellectually may be falling short. My intellectuality is falling short, Lordship. Kindly don't record.
No, it is, I am not saying your intellectuality is falling short. Otherwise, I would have not
No,
heard it. You at least have that basic amount of intelligence to appear
Fine,
before
that's
the
fine.
apex court of the state.
Problem.
Assumably, if you think yourself that you do not have that intellect, then you have better choices open for you.
No other chance.
Yes, yes. there are
Class
options.
5 and 5 though.
Yes, yes. You can go and obtain a job while practicing as advocate. You're wasting your time here.
Lordship.
If you don't have the confidence of having an intellect, then don't practice, sir. Don't practice, sir. High
But
Court
sometimes
apex
it lacks.
court-
Most
No,
of the
no,
time it
apex
remains
court is hearing
sometime.
on a presumption that you have something in your head.
Lordship.
Don't
You-
insult yourself, Mr.
No,
Valle.
Lordship. Usually I have, but sometimes it lacks.
That you did not record at the, so please do not insult yourself.
Lordship.
So BP Banerjee learned advocate appearing for the respondent number 5 adopts the submissions advanced by Mr. Banerjee and submits that there is no infirmity on the order impugned by the learned tribunal. Inasmuch as infirmity in the order of the learned tribunal and the said order would also reveal that the learned tribunal had made it clear that it has not expressed any opinion on the alleged charges as labeled in the impugned charge sheet. Mr. De Learned Advocate enters appearance on behalf of Union of India.
DRI. Respondent number 3, DRI.
Respondent number 3 and submits that no legal right of the lead petitioner has been infringed. No legal right of the petitioner has been infringed. The disciplinary proceeding is still continuing, and as such the right and as the petitioner has approached this court without filing a reply to the charges though called upon, the learned tribunal rightly came to a finding that the application was an immature, was a premature. Heard the learned advocates appearing for the respective parties and considered the materials of the court. So, the prima facie it appears that the authorities have not proceeded in strict consonance with the circulars of 8th of January 20. 8th of January 2020 and 24th of February 2011, inasmuch as though in Annexure 1, reliance was placed upon the statements of 3 different persons, comma, reliance was placed upon with tinte naam dete. Reliance was
in Annexure 1, Reliance was placed.
though in Annexure 2 of the charge sheet. Though in Annexure 3 of the charge sheet, the list of documents included statements of Sujit Swarnakar, Shubhankar Pal and Arjun Adhikari. The said persons were not incorporated in the list of witnesses in Annexure Roman 4. In circular dated, where is that circular you said?
At page 71
In
and 69 as well.
circular dated,
24th February 2011.
circular dated 8 January 2020. It has inter alia been stated Can we? Yeah, you have to wait for it. Page 64.
The circular is the 8th of January 2020 and has entirely been stated. Stated.
It has inter alia been stated that unless a person unless a person upon whose statement reliance has been placed, is made a witness, is not a witness, and is examined before the inquiry authority. Can be used against the CO, can be used against the charged officer in inquiry. In our opinion, arguable case has been made out by the petitioner. And accordingly, there shall be an interim order restraining the respondents from proceeding further with the disciplinary proceeding. Restraining the respondents from where is your prayer?
Page 49, my lord, of my writ petition, prayer G.
Accordingly, their respondents are accordingly, the disciplinary proceeding initiated on the basis of the charge sheet dated such and such is stayed until further, is stayed till the end of January 2024 or until further orders, whichever is earlier. Stop. The writ petition appears as the writ petition was dismissed at the, as the original application was dismissed at the admission stage, and reply and rejoinder were not as dismissed at the admission stage, the respondents would be at liberty to file their affidavit in opposition to the present writ petition within a week after the vacation. Reply thereto, if any, be filed within a week thereafter. This the matter for final hearing in the daily supplement on 18th of December. Yes.
I'm obliged, my lord. Deeply obliged, my lord.
Yes, next.
18 December.
Pleasure appearing before your lordship, and I convey my puja greetings to.
Never do that, Mr. Bennett. You are a respected, consider yourself to be a respected counselor.
That was said in a very lighter way. Otherwise, we would have not continued for 25 years.
At this age, you are lighter mood. It is going virtual. Everybody can hear it. that Mr. Banerjee has said he's not
Sorry.
fit to practice.
I'm sorry. I shouldn't have done
You
this.
may not have, but we have that.
I-
You are our officers.
Definitely.
How strenuously you are defending a case. That itself shows your effort. You could have said the stay for the limited part happens. We are vacation. Our
Right.
officers are not like
I was just on a very light.
our Calcutta High Court advocates are not.
No,
And I tell you one compliment for this Mr. Tate. Why I say, because I used to sit in a public interest litigation bench with Honorable Justice Nishita Mathur.
Lordship.
Then they were cutting down the trees from the Barasat area.
Yes.
The entire
NH expansion.
expansion as proposed to be compensatory or the remedial measures to be taken under the, what is that forest? What was that act? So they were all NGOs, poor persons approached in public interest litigation. So we were in a fix and we engaged him and
Mr.
one
Bishwarup Nundi.
Mr. Nundi. We engaged and they took a special officer of a court. What he will say, I will go there, I will take 300 years. But the effort that is put, it is for our Calcutta. So keep yourself up.
I tried to.
You are learned members, litigants are there.
I tried to. Lordship, on behalf of my bar, I did some good things. I mean,
I'm not saying we considered yourself. to
no,
be-
that was just a momentary on a light moment. I said, when I could not, yes, of course.
But that
I withdraw my that, but I shouldn't have said. I shouldn't have said.
Yes,
When I-
that should not have
No,
been.
when I said, when I could not make out my second point in a very firm way, then I found that either I should have been prepared earlier or I was falling short of that. Lordship.
We should be.
Of course.
Should get them.
Your client understand this, that you are running from centenary building to peace court to attend the matter. Never, your client will never appear. The state and blood that is put in by the advocates. We know. We know.
I know.
Yes, next.
Item number 12 is a passed over matter.
12. Passed over matter.
Yes, ma'am.
Where is that? Yes, who is your other side, Mr.
Sonojit Ghosh.
কোথায় গেল?
He was there.
Mr. Chakraborty is a.
Yes, my lord.
You are 8.
Yes.
You can tell us that Mr. Chakraborty is waiting. Where is the petitioner?
Lordship, Mr. Ujjwal Rai is appearing before the petitioner. He's on his legs at court room number 25, Lordship.
My lord, may I make only one prayer? May I make one prayer? My lord, since I am indisposed today, I am not ready. Kindly place it after vacation.
Lordship, kindly fixes it tomorrow at 10:30.
Now, tomorrow there are so many matters, my lord, fixed in court number 1. If your lordship wants to take it up, it's a question of, my lord, recovery proceeding initiated earlier. It was done. And then, my lord, the tribunal did not interfere with such recovery proceeding. Then why is the scope for passing an interim order at this stage? Kindly fix it up on 17th November as specially fixed, we shall argue.
Because you are deducting further amount. Tell us that you
grateful,
will not deduct, we will keep it on that. Till 17, don't deduct, we keep it on that.
Very good, very good.
Will we record Mr. Chakraborty, your statement?
No, my lord, kindly do not record this. Let it be court's order because that is very.
Call Mr. Chakraborty. Can you?
My lord, I have initially submitted that since I am indisposed, I am not ready today. If your lordship wants to take it up, kindly take it up on Thursday.
Thursday, Mr. Chakraborty is the last date, na?
But your lordship will be sitting at least 1 hour.
Yes, yes. We will be certainly sitting. There is no problem. No, but it was being said, Mr. Chakraborty, that if no further deduction is made, we have told that as
You know,
young.
it's a question whether the petitioner got an injury during office hours or he got an injury for his own fault. This is a question of fact. And
Yeah.
that is why that he withdrew money and that was being deducted.
No, he did not withdraw money, Mr. Chakraborty. That was paid by the railway. That was paid by the railway. Where is your advocate?
It's on leg, Lordship.
Which court is there?
He's in 25, Lordship.
এইটাই বলো। ওই ফাইলটা দাও তো মিস্টার চক্রবর্তী ওয়েট করছেন। মিস্টার মজুমদার জাস্ট গিভ আস Where is he?
Chief, he's on leg at courtroom number 25, my lord.
হ্যাঁ অবশ্যই। Mr. Royal Learned Advocate appearing for the petitioner submits that the authorities have already recovered an amount of rupees Mr. Royal appearing for the have already recovered an amount of rupees. Are you working there? You're working there.
I'm not in possession of any instructions, my lord.
Facts. Open your don't know the facts. Your advocate is not appearing, and
Sorry, my lord.
a senior counsel is waiting for your advocate.
Bro, your lawsuit will be rising today at 3:30, I understand.
Then Mr. Chakraborty, it will be there tomorrow, appear for 5 minutes over virtual.
No. Tomorrow I have some specially fixed matters before court number 1. Kindly do not repeat tomorrow. Or if your lawsuit want to keep it tomorrow, kindly place it at 2 o'clock.
All right. Then tomorrow at 2 o'clock it will be there, Mr. Chakraborty, so that we can.
Yes.
কালকে 2 PM দিয়ে দাও এটা। Yes, Mr. Majumdar. What is your pressing urgency?
Time is very short, Lordship. Kindly take it tomorrow. Kindly take it tomorrow. Because time is very short. Because today is 3:30.
When the when is the next date of the proceeding?
My lord, proceeding is going on hottest. Lordship, my lord, they are bent up to remove me from service. Lordship, you would be surprised to see the charge sheet.
Yes, tomorrow.
Tomorrow, my lord.
Tomorrow we don't know. Tomorrow we have another fixed matter.
Lordship, my lord, tomorrow top of the list, my lord. Tomorrow top of the list.
Tomorrow we have already a fixed matter at 10:30, Mr. Modi.
Thereafter, my lord.
Lordship, in respect of item 64 of the combined list, Lordship, your Lordship had directed me to give notice to the Union of India. I've received a letter from the Union of India asking for the particulars of my client. Therefore, I was praying, let it go after vacation, then I shall be. Lordship, item 64 of the combined list. I've received a letter from Union of India just to
Can you hear us? কি গো কি add করছো? হয়েছে add করছো তা শুনতে পাচ্ছেন না? হ্যাঁ মিস্টার চক্রবর্তী ক্যান ইউ হিয়ার আস? আমাদেরটা ওনারটাও তো শুনতে পাচ্ছি না।
Yes, my lord, yes, I can hear yes, lordship.
Yes, he has come. We are keeping it, Mr. Rai, keeping after the vacation. Mr. Chakraborty is appearing till such time. We are passing. How much amount was deducted from you?
60,000 each month. Last month I have got the salary now. I got the salary slip now, my lord, which is, my lord, 70,000 a month.
Mr. Royal Learned Advocate appearing for the petitioner submitted
slip of the last month.
Submits that an amount of rupees 59,000. Where is the amount?
My lord, lordship has seen the salary slip, my lord.
No, that was stated in the order.
Yes, that is 15. I tell you.
Where is that? Submits that an amount of about 60,000 has already been deducted from the petitioner's salaries and the respondents are intending to continue such recovery, are intending to recover further amount from the petitioner's salary. And accordingly, he prays for an interim order. Stop. Mr. Chakraborty, Learned ASG, opposes the petitioner's prayer and submits that the petitioner is not entitled to the amount which is being recovered.
Because my lord, your lordships are aware that Sambabu Verma's case was subsequently changed by the Supreme Court.
We will
And
hear.
The petitioner's case is he got an injury during office hours, whether for his own fault or for the fault of the administration. That is a question of fact.
Yes, we will hear you that. Certainly we will. লিখেছো তো? This was decided on exchange of affidavits.
It was.
Reply rejoinder you
Yes,
have annexed.
yes, but yes.
We have been informed that the.
But I have, my lord, I did not annex, but I mentioned that I have annexed. So when it is left to be annexed, reply and rejoinder, I have got the copies in my hand.
Original application you have annexed?
I have annexed.
আচ্ছা, দিয়েছো? Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are of the heard the learned advocates and consider prima facie an arguable case has been made out by the petitioner, and in view thereof, the respondents are restrained from deducting any further amount from the petitioner's salary till the end of till 15th of December 2024. Stop. Mr.
15th December 2024.
Sorry, 2020. Till 15th of December 2023 or until further orders, whichever is earlier. Stop. Mr. Rai is directed to file a supplementary affidavit annexing the copies of the original application you have annexed.
Annexed.
You have annexed the original.
Yes. Reply and rejoinder I did not.
Annexing the copies of the reply and rejoinder. Within a week, Mr. Roy is directed to affirm a supplementary, directed to affirm a supplementary affidavit annexing the copies of the reply and rejoinder, and to hand over a copy of the same to Mr. Chakraborty within a week after vacation.
To my learned junior Mary Dotto who is appearing.
Acha, acha, to Miss Dotto. Where is she left? The learned junior, to Miss Dotto, learned advocate, appearing for the respondents along with Mr. Chakraborty.
Yes.
Stop. List the matter list the matter for final hearing in the daily supplementary list of this court on 11th of December 2023.
Grateful.
Grateful.
The affidavit of service and the list of dates, my lord, may be kept with the record.
My lord, list of dates you give copy to Mr.
I've already given copy to the learned junior, my lord, but once again, I'll give to my lord senior.
Affidavit of service filed by the petitioner be kept on record.
My lord, if it is permissible for me to mention my matter, lord, I am a dismissed IPS officer. I have been coming to this court. I am appearing in my own case. I have been coming to this case. This case is pending since 2014. Your lordship might have seen it me every Tuesday I come here. And I'm suffering from various diseases. Now I'm 67 years old. I only want, my lord, my case to be heard as quickly. It is serial number 19 in the monthly.
One thing, give a notice to your other set and come and mention tomorrow. We will consider it and fix a date for hearing.
Very good. My lord, but I don't know how to serve it on them. Your lordship may kindly fix it.
No, then you mention after vacation. We will keep it in the supplementary list on a particular date and finish it off.
So if I mention it tomorrow, then
who is your other side? Tell us.
Government of India and Government of West Bengal. They are not coming.
They
are not coming, my lord. For the last 2-3 years, they are not coming.
Then it is better. You give a notice and mention any day after the vacation in the morning, first sitting of the court. We will fix a date.
Grateful.
Right.
Grateful.
Grateful.
If you mention it, don't mention it on the reopening date. Please mention it then on.
Tomorrow I can mention it, my lord. I will serve the notice to them today. I will mention it tomorrow.
Even if you serve, we will not be taking it out within one day because we are closing. We will take it up after vacation. So you give a notice and come back and mention before us on 20th November.
20.
We are reopening on 17th.
Yeah, my lord.
Come to us on 20th with a notice so that we can fix on a particular date.
And if I come tomorrow or day after, just my lord, if you kindly kindly bear with me, my lord. If I feel,
so I don't know whether your your friends would be appearing
day after tomorrow. No, I'll mention them tomorrow or day after tomorrow or day after tomorrow. I'll fix it day after tomorrow, my lord. I'll tell them that.
No, day after tomorrow. Don't fix. That is the closing date of the court. You will not find the advocates.
Achha, my lord. Thank you, my lord.
Great.